Take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. The Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. Minds on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Rachel with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate. Take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial, trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Hey! Take it to trial, from day to night and every wild mile. Sweet Peas million strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
Y'all know I ain't played my song yet. I call it my song, but it ain't my song. It's actually the California people song, but I love it. So we're gonna listen to that one. Say like, what? Just while I let everybody get on over here and get settled. Make sure you didn't hit the like button. Y'all know how we do it over here. You gotta have something like to keep this a little light.
Junkie on the freeway, white claw in a breeze. 2 hours there, 2 back, still typing with ease. LA lanes locked, but she don't slow down. Show up every time, yeah, she runs this town. Sitting in the traffic, but she locked in chat. If Sweet Pea goes live, yeah, she's right on that. From the 405 to wherever we at. Junkie pulling up like y'all good, I'm back. Different time zones, same front row seats. No matter where we are, we all meet in the free. We the California's rolling deep on 9. 4 corners, 1 crew, yeah, the vibes align. From the coast to the chat, yeah, we show up right. If you're lost downstream, we gon' guide you like Californians. Yeah, we stay in the mix. 4 names, 1 flame, you can't remix this.
SD rolling with the sunset glow. West Coast haze where the good vibes flow. Little bit lifted, yeah, she stays serene. Ocean breeze mixed with the evergreen. Late to the stream, but she still gon' slide. Panel opens up, she already inside. Hold up, I'm here, yeah, she dropping bars. Calm, cool energy, no matter how far.
She got that FOMO, scrolling every stream. Little lost downstream, but she part of the team. New to the crew, but she locked in fast. Super chats flying, yeah, she built to last. Wait, where we at? But we got her back. Pointed to the right stream, never off track. Now she vibing with us, no need to roam. Anywhere we at, yes Susie home.
Shamrock, yeah, Shamrock checking in from across the map. Different time zone, but she bridging the gap. Y'all good every time, yeah, she mean that. Heart so big you can't teach that. Algorithm running, she keep it alive. Dropping love in the chat, keep the whole thing thrive. Quiet power, steady hand in the dark. Every stream glowing got a Shamrock spark.
Yeah, yeah. Junkie, 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 junkie.
Susie, Shamrock, Shamrock.
Junkie, 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 junkie.
Susie, Shamrock, Shamrock.
Where we at? California, say the name twice. Show up every stream, yeah, we never think twice. From the traffic jams to the ocean tide, from the lost links to the worldwide ride. Californians, yeah, 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 we stay in the mix. Four names, one flame, can't remix this. Yeah, yeah. Californians, Californians,
All right, crew. All right, all right. Hopefully that got everybody a beat, depending on where you at. Got you in the groove. Made you want to do a little move. Yeah, I did my best chair dance. Y'all do know y'all in the house with the best chair dancer in the whole USA. Now, if you ask me to stand up, it's probably not gonna work. But in this chair, baby, I can do some things. That's how we kind of got to this. Okay, so let's get in here. We are on day 3. We probably be able to get this wrapped up and get to a verdict. And that way we'll be going up to our rough trials with, well, not our rough trials, but we know we're going to be gangster this week. When we go be Foolio, I'm going to be whopper with the chopper. So we'll be over there in Florida, of course. And then we going to Hawaii to do our luau. You know, I was telling myself the other day when I was doing this, I gotta you know, the little luau girls that you get from there on my thing. Yo, cat was twerking. What'd you say, Black Love, about a girl is making fun of me that I'm gossiping with other ladies about another girl? You say you're not sure how to feel about that? Well, it's okay. Oh, man. Awesome. Okay, well, I'm not going to further delay us. We'll go ahead in here and get to day 3, see what we got here. Remember, we are looking at it from the lens of what did her defense attorney do wrong? I mean, what could he have done differently? I mean, is this really what we doing here? Wasting people to, you know, I love the judge, but he's the person that's looking at the appeal. I just really don't think that's I don't think personally that's appropriate. Like, if I was asking for an appeal, I would not want the same judge that seen the entire case to decide on the appeal. I would want it to go to a different judge and them be able to dictate it. That seems weird to me. It almost seems as weird as when a judge is when attorneys ask for a judge to recuse themselves or disqualify themselves. You know, when a judge is asked to disqualify themselves, they actually make the ruling. So it's like, if I wanted to just disqualify this judge, I write up this brief, I send it to the judge, and the judge reads it. So now the judge know why I don't like them, why I feel like they unfair. They know all of this stuff, and they decide not to take themselves off the case. That's what happened in the Alicia Andrews case, guys. So they told the judge all these things about what they didn't like, and you know, how she was biased and how she didn't give him a fair trial. And she looked at all this stuff and she said, nah, I'm not taking myself off this case. Y'all can kick rocks. Thank goodness they did take it to the Supreme Court in Florida, and the Supreme Court in Florida was like, well, all right, Cisco. Now look at all the stuff that they seeing on court TV, Law and Crime, on Instagram, TikTok, Facebook. Everybody sees that you biased. Like, how did you not take yourself off the case? And that's when they took her off the case. But it seemed like the most silliest process, because they really want judges to be be able to separate, but they human just like us. So I don't know how they expect for them to separate. I think that if you want to disqualify a judge, it should go to another judge to look at the disqualification. Now, why would they send it to the same judge? So silly. But I kind of feel like I don't want him to be over this. And I don't know. I do have it on my alert to check on it once a week, at least to try to see if he makes a decision in regards to it, but we'll kind of see. So, yeah, that's my thought. Let's go in here and let's see exactly what we have for day 3, guys.
People of the state of Michigan versus Shanda Vander Ark. This is day 4 of a jury trial. Record should reflect that Mr. Johnson is present in the courtroom representing this Vander Ark. Mr. Roberts is here on behalf of the people of the state of Michigan. Ms. Vander Ark is not present. My understanding, Mr. Johnson, is that she is suffering some medical distress this morning. And I know you want to put something on the record regarding that before we go forward, so you may proceed.
I do, Your Honor. My client is suffering a medical issue. We were hoping that, given some time this morning, we'd be able to get her to a point where she'd be able to come and join us. She'd be competent to do so. The court has been gracious for a trial that's supposed to start at 9 o'clock. It's now 10 minutes to 11. And we appreciate the court's grace in allowing us to work with her and hopefully get her to the point where she can come and participate in her own trial. I must report to the court at this point that situation has not occurred. That she at this point is not able to participate in trial, given this medical situation. As a result of that, she's been basically we've gone over a couple of options. One, ask to adjourn this case until a later date, but quite frankly, the situation that brought on this medical situation is occurring and is part of the stress of being on trial. So the reality is we couldn't guarantee the court that as of Monday or Tuesday or Wednesday of next week that we'd be in a different situation than they are in right now. And in fact, for the record, I anticipate we'd be right back to where we are right now, even if we waited a few days to work on things. Given that situation, I explained my client her options. She could come up to the courtroom on her own volition or with his assistance and participate in the hearing, or she could waive her right to be here and avoid this and not avoid, but to not participate as we go forward. She has chosen the latter. She's chosen to waive her right to be here. She's requesting not to come back again. For this purpose, she is not requesting an iPad or any other aid to allow her to watch the proceedings from where she is. She is content to rest at this point and simply allow her legal team to go forward, representing her in this matter and concluding this particular trial. Therefore, I'm asking the court at this point to continue with the trial and without my client being present. Thank you.
Okay, Mr. Johnson, my understanding too, as well as speaking to the deputies, I mean, I was asking, hey, what's going on with the progress? And they indicated that she had made some statements that she potentially could hurt herself. Is that correct? Your understanding?
I didn't hear them, but I heard those comments from a source that I rely on and have no basis to believe that's not accurate. And quite frankly, in conjunction with my experience with her this morning, I can see how she might have made those statements.
Okay, all right. So that was also a concern for the court as well. So, Mr. Roberts, any comments you wish to make on that?
Your Honor, the only thing I would ask, if we could at some point, and we don't necessarily have to do it right now, is because this is a critical stage of proceedings, that we would have something at the time it becomes available, something in writing from her, waiving her right to be here. In terms of her not being present, we also have to address the fact that she did not answer the jurors' questions. I've indicated in chambers that while I certainly recognize that the court rules do allow for jurors to ask questions here, that it is certainly not been a practice for a very long period of time, just recently adopted by the Supreme Court as a practice, and that I would think we could proceed without her presence and without answering the jury's questions. I think we have to address it in some fashion for the jury so they understand that, and they're obviously smart enough to look over the table and see that she's not here. But I don't believe that would in any way cause her testimony to be stricken here or allow the jury, put the jury in a position where they're not allowed to at least consider the testimony that has been given. It's probably frustrating for them, but quite frankly, a few of those questions were questions that weren't going to be able to be asked anyway because of different legal reasons. So I don't think there's anything here that we need to do in terms of, besides addressing it for the jury, however the court sees fit, and getting it right at this point.
Okay, Mr. Johnson, any objection to proceeding without the jury questions being asked? I know that I told both attorneys in chambers. It's a little bit frustrating to me because I think we told the jury where they have an opportunity to answer questions and they're getting deprived of that opportunity. But Mr. Roberts is correct. It's a relatively new practice. Are you okay proceeding without having those questions asked to your client?
I am, Your Honor, and I amplify what Mr. Roberts has just said. There are some courts even in this building, who do not even allow questions at this juncture. So it is a relatively new process. It is a situation that's unavoidable. I think the court is justified in informing the jury that those questions won't be asked, and then proceeding forward.
Okay. In terms of preference, Mr. Johnson, of what to tell the jury versus not tell the jury, my thinking, we could go as vague as, unfortunately, she's not available this morning. We could say she's had a medical emergency and she cannot be here. I guess it's I don't want anything we say to the jury to potentially prejudice her, but I'll leave it to you for your input, what you would prefer from the court.
Your Honor, I think what the court has expressed here in this courtroom is appropriate, and what we've expressed in the chambers. I have no problems leaving the court's. I'm not going to try to micromanage the things the court says. Simply expressing that she can't be here. It's a medical situation. Okay. That's all we've asked for, and I think that's appropriate.
Okay, is that acceptable to you, Mr. Roberts?
I'd have to defer to the defense on this question anyway, Judge. So that's okay.
All right. Anything before we bring the jury out?
Just briefly, Judge. With that, obviously, then Mr. Johnson will formally need to rest his defense. I do anticipate calling Lieutenant Hooksman to the stand. We've discussed in chambers again, just to revisit the 2 video issue very briefly. I did suggest this morning that perhaps an adopted admission instruction could be given to the jury based on Ms. Vander Ark's testimony about the contents of the first video. I think we've all agreed that the better course here, especially with her not being able to come up and participate in the proceedings today, that Lieutenant Hooksman will just simply testify to that. She said multiple times, if that's what the video shows, we'll just take some brief testimony from Lieutenant Hooksman, and we will still continue with the previous ruling, the previous agreement that was made here that we will not play that video for the jury. And then do anticipate playing the second video that we've discussed, and that was kind of been planned all along. Introduce that through Lieutenant Hooksman, and that video plays about 18 minutes or so. Just to caution folks in the gallery, there is no way to do this without projecting it on one of the monitors. I think the court's indicated that what it will do is raise the screen here. We'll project it on the TV so that only the jury can see these things, but the rest of the gallery certainly can't see those things from the camera perspective. It won't be captured, but the members of the gallery can see that. It begins with an image because the camera is fixed directly at Timothy, deceased, in the closet. There's only a few seconds of it. I've narrowed it down as much as possible, but there has to be some context for the jury so they understand. And the video starts within a few seconds of the defendant walking into that closet, and then what transpires from there is what is really the most relevant portion of that. But again, it's difficult to look at, it's difficult to see, and anyone that thinks that they are going to have a hard time with it, I would just suggest to them when we get to that point to exit the courtroom. But at a certain point, we can't pull the punches too much about what took place here, because these are terrible circumstances, and the jury, I think, needs to be afforded the opportunity to see what transpired in the basically 18 minutes that the defendant waited to call 911.
Okay, thank you, Mr. Roberts. Mr. Johnson, any objections to that?
No, Your Honor, I don't. And while we have an agreement, Roberts and I, as to the
That's interesting. Wait a minute. Let me get it back up here. I must be hitting too many things. I'm back here messing around, hitting too many buttons. I was looking at this one too, right here. Let me get back to the thing. Oh gosh, sorry y'all. I'm being nosy, looking at the sister and brother. Sister and brother murder trial against their mom. I was trying to see how many days it was. That
All right, ladies and gentlemen, where I left off, I was talking about.
Wait a minute. That wouldn't be one I wouldn't mind doing as a rewatch. At some point in time. And I was trying to see how many days it was, but yeah. So that's yeah, I'll wait and see.
Basically 18 minutes, the defendant waited to call 911.
Okay, thank you, Mr. Roberts. Mr. Johnson, any?
I'll get the volume together. Give me 1 second.
No, Your Honor, I
Boost
don't
it up
have.
again.
While we have an agreement, Roberts and I, as to the first video, the before video, there'll be descriptions of it. I'm not sure if Mr. Roberts is going to want an instruction as to why that video wasn't provided for the jury as well. I think that I wouldn't object to that. I think that's appropriate as part of our agreement, but he may have jurors sitting there saying, "Why didn't we get to see that one?" So if he wants an instruction for that, I would not have an objection to that either.
Okay, so yeah, what we're gonna do is, and I forgot to tell Mr. Weaver this, so what we're gonna do is we're gonna have the shut off, so that specifically out of respect for Mr. Ferguson, although this TV is going to be angled toward the jury, and obviously it's in view of the gallery, I do not want it broadcast out of respect for him. So this TV will be going, but and as well as the witness. But again, I'm instructing those members of the media that are in the courtroom today. I do not want this video, including images of Mr. Ferguson and his deceased, to be broadcast. So, with that, anything else before we bring the jury out, Mr. Roberts?
No, Judge.
All right, Mr. Johnson.
No,
All right, please rise. All right, you may be seated. All right. Good morning, ladies and gentlemen. Thank you for being here on time. It's been a while. We've delayed you. As you'll notice, Ms. Vander Ark is not present this morning. Unfortunately, she's suffering some medical distress this morning. The reason we've been delaying is we've been trying to alleviate that medical distress, and so the court was willing to wait a little bit while we did some other matters to see if she was able to be present. She is not. She certainly will not be present during this morning, and she may not be present for the rest of the trial. I don't know, but at least she's not here today. And again, it's not by court order. It's because, unfortunately, she's unable to be here because of a medical issue. So with that, we will continue the trial in her absence. Mr. Johnson. And that also unfortunately means that we will not be able to ask her your questions. It was my preference to have that happen, and I tried to get that to happen, but unfortunately we will be unable to do that. So, Mr. Johnson, any other witnesses?
No, Your Honor, at this juncture, the defense rests.
Okay, Mr. Roberts, any rebuttal witnesses?
Yes, Your Honor, would people recall the defendant?
Raise your right hand. Ms. Vander Ark, you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
And put your hand down, grab a seat. You can just go ahead, please, again, state your name for the record, spelling your first name and last name.
Lieutenant Joel Hoeksema, Joelhoeksema.
Lieutenant, I want to, let's just start off with, you brought People's Exhibit number 34 up to the podium there, or up to the witness stand with you there. That's the bottle of hot sauce. And you actually sees two of the same type of hot sauce from the residence. Is that correct?
That's correct.
That's one of those bottles.
That's correct.
And you heard the testimony yesterday from Ms. Vander Ark, where she indicated that there was some discussion about ordering the hot sauce from Amazon because you couldn't find hot sauce she couldn't find hot sauce that Timothy didn't like, or something to that effect in Myers. Do you recall that?
I do.
Could you go ahead and read for the jury the label there for that hot sauce?
Elijah's extreme regret is screaming super hot. It packs the fire of the two hottest peppers in the world, the Trinidad Scorpion and Carolina Reaper peppers. Your tongue will burn from the sting of the scorpion. Your eyes will tear up as sweat pours off your head. Your throat feels the burn of the Carolina Reaper going down. The pain becomes unbearable, and you feel like you just ate a burning hot coal. That's when you realize extreme regret, not for wimpy hot sauce lovers. Use with caution, or you'll regret it.
Okay. Now, did you also hear the testimony yesterday from Ms. Vander Ark in regards to two videos that were actually obtained as part of the investigation into this matter?
I did.
And let's talk about that first video first. It sounded funny when I said it. Talk about the first video. That it's a video that actually shows Timothy Ferguson being brought into the small room, but being brought into that closet just hours before he passes away. Are you familiar with that video?
I am.
And have you seen that video?
I have.
And we've made an agreement because of the sensitive nature of the video and its frankly graphic nature that's not going to be played for the jury. Is that your understanding?
That's correct.
I do want to unfortunately have to ask you some questions about it. So if you could just recall that video, and first of all, explain to the jury what camera that video was obtained from.
So we spoke earlier that we had seized several video cameras from the home. This specific camera was called a La Vue camera, and it was found originally during our the execution of the first search warrant right outside the door of the small room. Further into the investigation, it was discovered that there was a micro SD card within this camera that contained video files.
And that camera and the video that we're talking about, what does that what does it capture, at least in terms of an overview of where it's pointed?
So at the time those video files were generated by the camera, it was positioned within the small room in one of the corners, looking at Timothy when he was in there.
And you've had an opportunity again to review those, is that correct?
That's correct.
And at approximately 11 o'clock, 23:03 in military time, 11 o'clock or so, you observe Ms. Vander Ark on that video.
I do.
And what does she do?
On the video around that time that you mentioned, Ms. Vander Ark is observed placing a tarp into the closet and kind of spreading it out as a makeshift bed.
And after she does that, what happens after that?
After she lays the tarp on the floor, she is seen dragging Timothy by the arms onto the tarp and into the room.
And are you able to see Timothy's body at that point in time?
I am.
And what condition would you describe? How would you describe his physical condition at that point?
His eyes were open, but not really seeing anything. He appeared to be unresponsive. He didn't make any he didn't speak at all. He moaned a few times. It's very concerning watching that and seeing his appearance.
And you've also obviously had an opportunity to see both the photographs of Timothy at the scene as well after he was deceased and the autopsy photos. Did he appear substantially the same way that he appeared in those photographs as well?
He did. Very, very thin bones protruding. In particular, he wasn't wearing any pants, so I could see his hip bones and his knee joint very prominently displayed as she positioned him in front of the camera.
And did it appear that he was wearing a diaper?
He was wearing an adult diaper.
And you said that Ms. Vander Ark positioned him in front of the camera so that his what was facing the camera, I guess.
His face was facing the camera. It was the primary focus of the cameras to keep a view of his face.
And does that camera also records audio, does it not?
It does.
And did it record any audio from Ms. Vander Ark as she was pulling Timothy into the closet and positioning him on the floor?
It did. I could hear Ms. Vander Ark tell Timothy that he is pathetic, and then adds that, but I already knew that as she was dragging him in. She also makes a comment to him that you owe me the biggest apology in the world, and suggests that he wouldn't be able to leave the restroom or leave the room for restroom breaks unless she receives an apology from him.
And then did she leave the room at that point?
She does.
Did she come back a little while later?
I believe it was approximately 15 minutes later she comes back into the room.
And during that time period, though, are you able to observe Timothy on that video?
I do.
And does Timothy do something between the time that she leaves the first time and the time she comes back?
Initially, she had positioned him on his side with his face facing the camera. And over the period of about 15 minutes, he rolled onto his back. So his face was no longer visible.
When she comes back in the second time, what does she do?
She repositions him so his face is visible to the camera. She has one of her Great Danes come into the room and instructs the Great Dane to lick his face, trying to get what appeared to me trying to get a reaction out of him, and even makes a comment to the dog saying that, see, he reacted to you.
And so does the Great Dane, does the Great Dane stay in the room at that point or not?
It kind of steps over him, licks his face, investigates, and then eventually leaves the room after she provided the dog instructions to lick his face.
And what does she do at that point?
During this time, and previously while I observed Timothy in the room, he was taking short, shallow breaths through his mouth. Kind of picture how a fish out of water would breathe, with gasping for breath through their mouth. And she clamps his mouth shut, tells him that he doesn't need to breathe like that, and then holds his mouth shut for a period of time until he's forced to take breaths through his nose, and tells him, see, you didn't need to breathe through your mouth like that. You're being a dummy or an idiot, something along those lines.
And does she leave the room at that point?
She does.
And is that the last time anyone actually has any contact with Timothy in that room?
That's correct.
And you've had an opportunity, does that camera continue to record all through the night into the next morning?
It does.
Because this was about between 11 and 11:30 on July 5th, is that correct?
That's correct.
And so the camera records into the next morning, is that correct?
That is correct.
And you've had an opportunity to watch all of that video, is that my understanding?
Yes.
And at some point, does it appear that, and you're not a medical doctor, I understand that, but does it appear that Timothy actually passes away while in view of that camera?
Yes, it appears that way to me. He can be seen, his chest rising, lowering very slightly, small little movements, and then there is a point in time where you stop seeing that, and his body just kind of relaxes, and it appears to me that he has died at that point.
And does from that point on, is there any movement of his body until the next morning? Is there any movement of his body at all to indicate that he's moving or alive?
There is not. There is no more movement from his body from that point.
And we're going to now play for the jury you're aware that there was a recording that takes place later that morning, is that correct?
That's correct.
Starting around approximately 6:20 or so of that same camera, is that correct?
Yes.
And just give they'll be able to watch it and hear it, but what are we looking at initially when we see the video?
Initially, you'll see Timothy as he was positioned And then you'll see Ms. Vander Ark enter the room, and you'll see her reaction regarding finding him. What I know to be deceased, but I don't believe she does at that time.
For the record, this would be People's 46. It's on a flash drive. It's pulled up on my computer, ready to go. So the jury understands I think the court's intention is to only play it through the monitor by the jury box. I think everybody can see that.
Can anyone see Mr. Weaver, can you maybe angle the TV out just a little bit?
You're probably going to want the lights dim too.
Yeah. I'll do it. I got it. Hold on, let me see. Mr. Roberts, are you connected to the? All right, let's.
I think we'll just confirm that's not in view of the camera.
I don't believe so. No.
It can be pushed closer too. So
What do you need? Wait.
Yes.
I said it can be pushed closer too. So
If you're worried about it.
Oh no, I've instructed them not to record it. So we didn't lights on it, and then I'll worry about getting him on here. So. Lieutenant, you can, is it on your screen?
There is nothing yet.
Okay, nothing yet, but you can see the
Yes, I can see
D.
the normal screen that's been appeared.
Okay.
That's been on it.
Do you have to hit something? Because it's not showing up. I've got G and C.
it's not over. I don't have it on mine.
Reconnect the NC Wi-Fi. Go back number.
I'm showing DA. If I do my phone, I can see it. Mike, you want to maybe grab the cart from the or the laptop from the cart?
We have a laptop.
Oh, okay. All right. Well, let's do that because I can see it on my phone when I pull it up. So
You can. Oh wait, I don't know that C popped up. Maybe we just give it just a second because circuit port C just popped up as well. So maybe it's
okay.
Can you see if you can connect D first? Slowly. That's the TV. Try to handle that one. So you want TV in here? Go for it. See what happens. Yeah. It's connected.
All right. Get Sean down here.
Hey, Sean. You head up there.
Sir, Your Honor, could it be because that's turned off? It doesn't go run through that?
It'll still go on here. It lines up and it's just another screen basically. So
I don't know if that was the central hub that.
no, it's not supposed to be. Okay, why don't we do this? We'll just take a recess until we can figure the tech issue out. Why don't we just bring him back to the jury room? So, all right, please rise.
Yeah, I just thought her attorney said that in the appeal hearing, like when he was trying to explain to the judge how good of a job he did, he was saying that the one good thing is that they got the video out. So it must have been another video that they got out that they were not able to
see. We'll be in recess. Just let us know when we get everything figured out. We got Sean coming up to figure out tax.
God, I don't even remember this part. So this is gonna be, I don't know if I wanna, I mean, we're gonna listen to it, but yeah. I don't remember this part.
Ladies and gentlemen, we have our technology issues fixed, so you may proceed, Mr. Roberts.
Thank you. Again, for those in the audience that have not seen any of these images, this is not easy footage to watch.
No.
Okay.
And it's still very, very wet.
Well, I think I feel moving.
Timothy, hey. Hey,
Come on, buddy.
Timothy.
Somebody. Sharma, stop. Okay, give another breath, please. I saw him moving during the night, maybe.
Yeah. Timothy, come on.
Come on. I'm gonna go get some water, see if we can get it done. You okay? It's all figured out for you. We can't close his eyes, that's usually a sign that he's not strong, but somebody. Can you open his jaw for me? Come on. Please, buddy. Come on. Please, come on.
Timothy.
Come on, buddy. Come on, baby. Come on.
Come on, Timothy.
Here. Let's get out of here and sit him up or something. Come on. I may end up being late for it. I don't know. Just gotta make sure he's okay. No, this is not good. I'm glad we checked on him.
Yeah.
You gotta put a 5 minutes to do that. Come on. You're okay. Get a pet back when you do that. Come on, go away. Keep going, keep going, keep going. Well, then, that's a good thing. Come on. Go give me a towel quick. Come on, buddy. This cannot be happening. Come on, buddy. Come on, Timothy. Come on, buddy. Hurry up, please. There's one in the bathroom. Come on. Come on, Timothy. Come on, buddy. Come on. Can't do it till we get him out quite quick. Come on. Okay, that's progress. Come on. Come on, buddy. Come on. No, that's one part. There's nothing in this smell. There shouldn't be. Come on, come on, get it flat, dude. Keep going. Come on. No, try to get back. Come on, buddy.
Oh my, get back.
Come on, buddy.
Mama?
What? Did you get something? Keep going. Keep going. Here, you shut off. It should be faster. I don't understand.
I don't either. Should we call an ambulance?
Not yet. Come on, Susie, come on, buddy. Come on. Oh, where's this? Oh, come on, buddy. You should be able to put stuff out. His dog was there. Yeah, yeah. Somebody. Put it on me very quickly. Somebody, go. Connect to me. Or Shanda. Somebody check on him. Yeah. Go. Come on, Shanda. Come on. Now is not the time. No, it's not. Yeah. Good. Yeah, I know, there's nothing I can do. When I push in and push stuff like that, when I go in, you know. Yeah. That's nothing new. Is there something that's with him? No. Nobody. Back to it. Is the seat in that one? Hold on. No. No, no. Wait. It's all day, you want. Somebody. Yeah. I know this one. No, okay. Here, I'll be with you. Give me this help. Not too much. Come on, buddy. Come Okay. He ate yesterday, but he hasn't eaten. He's driving me crazy because he wouldn't eat hardly. And so he got really skinny and he won't eat. And I was just about to call the doctor this morning because he's just been horrible. I mean, he's a teenager. He's 15 and he didn't eat yesterday, but not a lot. I checked on him at, I don't know, 5:30. Yeah. Yeah. Go and lock it up. I told you to go lock it. Shanda. Yes. Yes. Yes, I am. Yes. Yes, I do. Pinch his nose, open his airway. He's got like brown stuff coming out of his mouth. Yep. I don't know, it's brown liquid. Scoop it out. It's like dribbling out. Okay. Yeah. 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 Sure. 1, 2, 3, 4, 5, 6. Sorry. 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. Yeah, my 20-year-old's standing right here. 21, 22, 24, 25, 26. Okay. 30, 31, 32, 34, yeah, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 50, sorry. Yeah, he is. Yeah. He's on the spectrum, high functioning, and he has ADHD. Yes. It's not the first time he's done this with not eating, so. Okay. He's still going. It's possible. But my husband had said that I had a stroke in January, and then his dad and stepmom called us last week to tell us they were divorced. And so it's been rough, and he's been, like I said, he's done a hunger strike before. I would have been more worried. Hold on, go, I got it. Go, I'm here, sir. I don't think there's anything in his reach, honestly. Benadryl's the only thing, or, Off-brand Excedrin, extra strength. He's been on a hunger strike for like 2 weeks. Yeah. About 5:30 this morning. And then I came down about, I don't know.
couple of quick questions there. You heard references in there a couple of times, Ms. Vander Ark, in that 911 call mentioning going to check on Timothy at about 5:30. Again, you've had an opportunity to review all of that video. Is that correct?
That's correct.
At any point in time around 5:30 or any time after the video that you've described where she drags him into the closet, does she come and check on Timothy?
She does not.
Okay.
All right, do we have any jury questions? As far as you can tell, Mr. Rieger, you want to check? No? Okay, you don't. All right. You can stand down, Lieutenant. Thank you. Any additional? All right. So at this time, while we're close to the noon hour, we've had kind of a break in the morning. I guess I'll leave it to the jury. I don't want your answer now. You can go back and certainly talk about it. We do have some final jury instructions we have to do. We'll have to do.
We have to close as well, Judge.
Yeah, I understand. Well, I guess I suppose you guys want to take the lunch hour to prepare closing, or I don't know. Mr. Johnson, you prefer to have a break for lunch before we go into closings?
Yes.
Thank you. An affirmative answer. Thank you. All right. So at this time, we will take a lunch break. Please do not discuss this case with anyone. Please don't look at any social media, any news reports. Don't discuss it amongst yourselves. I know that the proofs are now concluded. However, until you're instructed and you're told by the court to begin deliberations, you're not permitted to discuss this case. I will have, we'll make it a shorter lunch, have you return here at 1 o'clock with the hopes to start it shortly thereafter, maybe 1:05, 1:10, something like that. That way we've been here. You've been this morning, and unfortunately, we lost some valuable time this morning. So have you back. We'll do closings. Then we'll slim it from 14 to 12, and then we'll give some instructions, and then we'll slim it down, and then hopefully get commenced with deliberations. Please rise.
Yeah, I don't think that I don't think she videotaped it, guys. And it wasn't body cam. What it was is that, she had cameras on him at all times in the house. So when he passed away, the cameras that she had pointed on him actually caught those moments. But yeah. Okay, so they come back. Y'all know she not in the courtroom because she wanted to play games this morning, acting like she couldn't come in the courtroom. She can't answer no questions. She gonna hurt herself. She may run. You remember they said she was talking about she was gonna run. Oh, that would be nice. I'm telling you, I want them to get in court one day and run so I can see the shock. So, yeah, so those were her own cameras that kind of took. She had cameras everywhere, so that's her. She recorded everything, recorded that, and they got the recording. And there is no way that she could get around any of this stuff, right? This an underage child. He passed away from starvation and dehydration. Any parent would see this stuff, so there's really no excuse. So. I don't know. She told the officer that she wanted to run. That's what she told the officer. She said she was going to run or something. I said, well, I can't wait to somebody do that so they can get the shock of their life. Well, because I'm pretty sure they're going to have a little shocker on their ankle or something. And I just want to see somebody do the Harlem Shake. That's all. If anybody that sees this and they going on trial and they are a defendant, if you get the little electric shock on your thing, can you try to walk out the courtroom door so I can see them shock you and you do the Harlem Shake? Yes. So let's go into the closing arguments and see what's going on. It's just always my thing for content purposes that I'm in the courtroom one day and somebody just definitely tries to take a dash for it. And I don't want them, they can't pew them. I don't want them to pew them. I want them to have that electric thing so they can shock them and so they can just start doing the Harlem Shake like, ooh. Oh, that would be so viral. Come on. I need somebody to do it. Who we going to court with next? Okay, so the next people we going to be doing is the Fulio defendants. They probably won't do it. They probably scaredy cats. I need somebody to do it. Like, we probably could have got Ronnie O'Neal to do it, or maybe Daryl Brooks or somebody like that, so they can get the shit shocked out of them so I can see it. Just see them fall on the ground and just get it on. Oh, yes. Yes, the things that we asked for. I know. Okay, let's get back in here so we can listen to the closing arguments. Remember, she's not in the courtroom. She even said she can't do no more. She can't do it no more. So she in the back somewhere.
You may be seated.
Before the court is filed 23110 FC, People of the State of Michigan versus Shanda Vander Ark. It's the continuation of the trial. After the afternoon break, the jury is secure in the jury room. Mr. Johnson, before we proceed, I just want to inquire in terms of your client is not present in the courtroom. Can you give us an update from your perspective on her?
The situation remains as it was, Your Honor. My client desires not to attend further.
Okay. Have the people had a chance to review the proposed jury instructions and verdict form?
Yes, Your Honor.
And any additions or corrections to those?
No, I believe they are satisfactory.
All right, Mr. Johnson, have you had an opportunity to review the proposed jury instructions and the proposed jury form?
I have.
And, or excuse me, I should say verdict form, and any additions or corrections you have?
Thank you.
All right, well, it's my intention after closings to go right into closing instructions. Any objection to that, Mr. Roberts?
No.
Mr. Johnson?
None.
All right, let's go ahead and bring him up. Mr. Weaver, please rise.
I know.
What is that?
All right, you may be seated. All right, welcome back, ladies and gentlemen. We'll commence with closing arguments. Mr. Roberts.
Good afternoon, ladies and gentlemen. Once again, on behalf of the people of the state of Michigan, I want to thank you for your time and attention to these matters. As we've repeatedly indicated, and as now you've seen through the evidence and the testimony in this case, these are incredibly difficult, incredibly sensitive matters. And we certainly do thank you for your time and attention to them. I usually like to start closing statements in a homicide trial such as this by showing you a photograph. And that photograph is usually the victim in the case prior to their death. In this case, our victim was a child. Would hope to be able to show you a photograph of what he looked like within a few months of his death. I can't do that. I can't do that because the defendant apparently took it upon herself to make sure there were no photographs taken of the victim in the 6 months leading up to his death. In opening statement, I told you about that song, What's the Matter Here? And the line from that song, answer me and take your time. What could be the awful crime he could do at so young an age? So ask yourselves that. What was the awful crime that Timothy committed to have these atrocities perpetrated upon him? What did he do? He stole some food? He took some things apart? That's all I heard. And he paid for that with his life. And like I told you, I can't answer the why. I can't answer why the cold and lowly things were done to him, because it doesn't make sense. It does not make any sense that a 15-year-old should be made to suffer the way Timothy was, to be made a prisoner the way Timothy was. And make no mistake, he was a prisoner in that home. We give prisoners rights. Prisoners of war have rights. Timothy had none of those because the person charged with his care and custody refused them, kept him locked up in the basement of that home with motion sensors and alarms to make sure he didn't even go upstairs, let alone anywhere else, but not to even go upstairs. Alarms on his body to go off. He didn't like the noise. Motion sensors on the stairs if he tried to go upstairs. Alarms on his small room, closet, door if he tried to get out. Motion sensors if he put his arm down during a punishment. Cameras watching every moment. And at the heart of all of this, the defendant. That alone, ladies and gentlemen, is the basis for first-degree child abuse. The serious mental infliction of harm upon Timothy as a result of her actions is all you need to find that the defendant is guilty of first-degree child abuse. And that's the tip of the iceberg. Towards the end of Ms. Vander Ark's testimony yesterday, I kept pressing her on that question. What did he do? What is it that he was doing? Apparently so desperate for food that he ate frozen chicken nuggets and uncooked hamburger. Explain this to the jury so they can understand, so they can make sense of why it was that you chose to do these things to him. And she got mad at the end, towards the end of her testimony. It became clear that she was still mad at Timothy. He was sneaky and deceitful. Over and over again, he was sneaky and deceitful. He'd sneak things when he wasn't supposed to. He was deceitful. He would lie about things. And you heard over and over again in the text messages. He's lying about that. He's not going to get away with it. This is all fake. All of those things. So ask yourself this question. Who do we know was sneaky and deceitful here? The defendant. And it started when, after 18 minutes of her son being unresponsive and so obviously deceased, she finally decides to call 911. But she better get her story straight before we call 911. So what's the last thing she says before she calls 911 to Paul? We'll have to tell him he's been on a hunger strike. Before that, where's your belt? Put your belt on him. I want to make it look like he's been this way. No emotion in her voice, no tears. Start with, why does it take you 18 minutes to call 911? You saw the image. You saw Timothy laying there on the floor. You heard them repeatedly talking about how he was stiff, how he wasn't moving, how he wasn't breathing, how his eyes were fixed open, and they don't call 911. Who does that? How does a parent do that? Paul asks her, should we call 911? Should we call for an ambulance? Not yet. And it's almost another 10 minutes before she calls after that. Then when she calls 911, the lies start. I came and checked on him at 5:30. And then when I came down, he was unresponsive on his bed. Both Completely false. We know he wasn't checked on at 5:30. We know the last thing that she did and said to her son. You could hear it in Lieutenant Hooksman's testimony today. The last thing she did to her son was to drag him into a small room, throw him down on the ground like he was a piece of meat on a tart in the room where she says he wanted to be. That was his comfort. Positions him in front of the camera so she can see. Calls him stupid. Then when he has the indignity to roll over, no, that's not good enough. She comes back. Positions him again in front of the camera. Makes the dog lick his face to get a reaction from him. Holds his mouth closed and said, "See, dummy, you don't need to open your mouth to breathe." Imagine those being the last words you said to your child. So that's what it was. That's the last thing anybody said to Timothy. You don't need to open your mouth to breathe, dummy. Shut away in isolation after months and months physical and mental abuse at the hands of the defendant, and Timothy slipped away. No, I went to check on him at 5:30. Lie. I have to put you on hold because I have to pull him off the bed. Lie. He's been on a hunger strike for the last couple of weeks, but I was just about to call a doctor. Lie. Then the lies continue. Officer Peasky, Detective Peasky, interviewing the defendant. Why is there a lock on the fridge and the freezer? He's got access. The locks are on the fridge and the freezer because he would leave the door open, but he has access to the pantry. Lie. Text messages over and over again talking about how he was able to get into the pantry and her repeated commands to Paul starting in February to make sure that all the food is locked up and Timothy doesn't have access, including the pantry. Yesterday on the stand, that shifts into, well, he did have access to a small cabinet where there were some canned goods. So this boy who was dying of emaciation, we're supposed to believe that he's going to have the ability to go into a cabinet to get canned goods, get a can opener, open them, and cook himself some food. Well, we know that's not true. He's not allowed to have food. He can't do that. The only thing you can hear in these text messages that he's allowed to have for those last few weeks after the June 13th photograph, which we'll get to in a minute, is the bread with hot sauce. Did you hear any testimony from her about full meals that she would cook for him? Anything? No. What's her response when she gets sent the picture? He's too, Mama, we need to actually feed him. That's the phrase. We need to actually feed him. He's bone thin, Mama. I think honestly, we need to actually feed him. And what's her response? Give him bread. Give him bread with peanut butter. The unresponsiveness is probably fake, but I see what you mean. Yesterday, she wants you to believe I didn't see that photograph. She literally uses the word see in her text message. I see what you mean. And then tries to split hairs about what that phrase means. Let's assume she didn't see the photograph for just a moment. Your child is so alarmed that he's saying he's bone thin. I think we actually need to feed him. And your first response is give him bread. What does that tell you about her mindset? Her mindset is that's what he gets to eat. He gets bread, maybe some peanut butter. That's what he gets to eat. Not the canned goods that he can get access to under the cabinet. And heaven forbid he commit the crime of sneaking a piece of candy or eating some frozen chicken nuggets. Give him bread. Detective Peasky. Well, after the stroke, he went on a hunger strike. That was a lie. Paul told you it was a lie. He never went on a hunger strike. There isn't a single reference here to him being on a hunger strike in January or in July. The bigger binder, more of the text messages, just about Timothy. All of the text messages, just about Timothy. I gave her the option yesterday. I said, show me the text about the hunger strike. You're so concerned about everything. You're so concerned about watching the cameras, setting the alarms, making sure the food is what it's supposed to be, making sure he's running stairs, doing wall sits, getting cold baths, all of that stuff. Show me in here where you're talking about him being on a hunger strike. No. The hunger strike thing isn't real. And think about it for just a moment. If your child was on a hunger strike, what would you do? I know what I'd do. Remember, we talked about reason and common sense. What's the reasonable thing to do? Get your child to a doctor. Get your child to a therapist. Get your child to something. But what does she actually do? The first set of text messages we hear, the first text message, February 18th. So this would be on or about the time of that first hunger strike. First, rude, and second, why are his hands free? Ooh. That's where we're starting. Why are his hands free? Because he's a human being. And what did he get into that he felt he needed to brush his teeth to hide it? I think most parents would be ecstatic about their child actually brushing their teeth. I know I am, and my kids do it. But to her, him brushing his teeth is a sign that he's hiding something. Sorry, didn't know he was up. What do you mean you didn't know he was up? Has he not been upstairs against the wall? So he's supposed to be against the wall. No. What? Why the heck not? What the heck has been going on? Check the brownies in the kitchen. Check everything not locked away. Check where the flipping keys have been. This is in February. We're not even talking about the last couple of weeks that Timothy's alive. This is in February. And she's already started talking about locking away food. 5 months before Timothy dies, and she's talking about restricting his access to food. Hunger strike? No. She realized late last night that he was thin, threatened to take him to the ER if he didn't eat. We know what she did to him the last night. She wasn't remotely concerned about his physical appearance. Make no mistake, she could see his physical appearance because she dragged him into the closet, and Lieutenant Hooksum had described to you in unfortunately vivid detail. And the images are horrifying, truly horrifying. But you've seen the photos of what he looked like when he died. And that was hours before. A mother dragging her child into a room, throwing him down on the ground. Does that sound like I realized last night he was ill and I threatened to take him to the ER if he didn't eat? So I made him a piece of toast with butter on it. She even admitted that was a lie. Said he was done after he ate the toast, went downstairs. He couldn't even move at that point. You heard Dr. DeYoung's testimony about what happens to the body as it breaks down, as it goes through these stages of malnutrition. 69 pounds. The average, and he was average height, the average 15-year-old male is 132 pounds. He was 62 pounds underweight. And we saw what he was like 3 weeks before. Make no mistake, she saw what he was like 3 weeks before. She got ready for work in the morning and went to check on him. No, that's not true. But it's interesting that she mentions getting ready for work. Because on that video, you can hear her. And she's been working on Timothy for a number of minutes at this point in time. And she says, well, I guess I'm going to be late for work, but we've got to get him responsive. Talk about cold. I guess I'm going to be late for work. Your child is dead. And all you can think about is being late for work? She had to have Paul help him get off the bed. Lie. On a hunger strike 2 weeks ago. Lie. There'd no pictures of Timothy since January. That one's true. And then when the detective starts to ask about the unusual things in the house, that what light shackles? What are these light shackles for? Oh, those are Paul's light shackles. Now bear in mind, this is hours after this has taken place. And it's just lie after lie after lie. How do we know it's a lie? May 18th, the Wisely transaction is handcuffs and leg cuffs for Timothy from Amazon. Figured it would be okay to get those right away so we can talk about the sensors and stuff. That's her text message. The handcuffs and leg cuffs for Timothy. Well, I would never use them on Timothy. June 27th, he's moved around, so he got the cuffs in front of him instead of behind him. So he's handcuffed behind his back. I put the cuffs back behind him. Her. I put the cuffs back behind him. I will have to deal with less than 2 hours of sleep today, but not letting him get away with this BS. June 27th. That's 2 weeks after the photograph goes to her, showing how thin he is, and he's handcuffed behind his back by her. Could this be any more about her? Could this text message show you any more how this was all about her? I will have to deal with less than 2 hours of sleep today, but not letting him get away with this BS. It's all about her. Fell out of bed at 5:30. Nope, never happened. Never went to check on him. The last thing you said to your child was, "You don't have to breathe with your mouth open, dummy." Oh, there's alarms on that room down there because we had the sewing stuff in there. Lie. The cameras were in the home because Gabriel would strip down naked and wander around. Maybe a camera was in there for that. But she doesn't care about wandering around naked. You heard the text messages. Timothy had to clean the garage with nothing on below his waist and then stand against the wall with nothing on below his waist. He had to earn his right to get clothes back. She doesn't care for kids that are running around the house naked. It's a form of punishment for her. Doesn't restrict his movement with shackles. Another lie. Now, Ms. Vander Ark was up here yesterday for quite some time. And she told you about what an intelligent lady she is, and I will give her that credit. She is a highly, highly intelligent lady. It takes a lot to finish second in your class in law school, graduate magna cum laude. It takes a lot to get a score of 182 and pass the bar exam. Heck, it takes a lot to just pass the bar exam, let alone get a score of 182. So this is a highly intelligent woman we're dealing with. She clerked for not one, but two different judges, was clerking for a judge at the time her child died. Yet she wants you to believe that she doesn't remember any of this. Can't remember any of these things. I don't remember that text message. I don't remember doing that. I don't remember saying that. Every time she's confronted with something that she did or something that she directed to be done to Timothy, she can't remember. How does this woman hold down a job as a legal clerk? If your memory problems are that bad that you can't send these text messages, how are you not seeing a therapist? How are you not on medication to address these issues? You couldn't hold down a job if you were that, let alone a job as a legal clerk, if you had that many memory problems. Let's talk about the things that she can remember. Oh, right after Mother's Day, he weighed 104 pounds. And I asked a couple of times, 108 pounds? No, 104 pounds. Absolutely certain about that. Somehow she can remember 2 months before Timothy dies, what he weighed. That's a detail that she can remember. The bad things? No, can't remember any of that. That's the detail that she can remember. How self-serving is that? That you can only remember the good things and you can't remember the bad things. And 3 weeks later, that's how he looks. Does that look like 104 pounds? Sure doesn't look like it to me. There isn't a single text message in here or in there, the larger binder, where she says, what are we doing? I don't understand why we're doing these things. Why are these things happening? Why is Timothy on a camera? Why is Timothy in handcuffs? Why is Timothy locked away in a small room? If she has all these memory issues, where are those text messages? Where are the memory issues in here? She knows everything that she wants to have done, and she's telling Paul day after day after day what to do to Timothy. Not struggling to remember what it is, not struggling to remember what it is that Timothy had done to be punished in this way. Not struggling with any of that. She doesn't have memory problems. She might have chosen at this point to block those things out from her memory. But make no mistake, all of these things happened. She did all of these things. It's only now that suddenly she has memory issues. So stressed out, so much stuff going on. Not so much stuff going on that you can't spend half of your time at work, especially in those last couple of days, just watching the camera. Watching while Timothy's in the bathtub for hours on end the day before he dies. Telling Paul to pour more cold water on it. Telling Paul to take a pizza roll. Take a pizza roll, warm it up, hold it in front of his face and see if he reacts, but be ready to snatch it away if he tries to eat it. This is supposedly when he's on a hunger strike. And you're going to bait him with food? She did all of these horrible, horrible things. And she doesn't get to hide behind saying, I just don't remember doing them. Or I didn't intend for Timothy to come to any harm. Of course she intended for Timothy to come to harm. Of course she did, ladies and gentlemen. No rational person, no person who can score 182 on the bar exam, let alone any other individual, no parent, nobody with the logic and reasoning skills that she has could not understand the consequences of what she was doing. I didn't intend for any of this to happen. We don't even know if that's true. It's not. But we couldn't even say that that was true anyway. She can barely even say that because by her account, she doesn't remember doing any of these things. For all we know, she did intend for all of these things to happen, which of course she did. And remember, we talked about the cookbook in voir dire. Went over it a couple of times. Unless you hear a defense from the judge in these instructions that says, if you find that the defendant just doesn't remember these things, that she can be found not guilty, she doesn't get the benefit of that. Don't add to the cookbook. Don't give her a defense that I just don't remember doing these things. I hope on some level, maybe she doesn't remember these things because they are so cold. They are so lowly. They are so dangerous that they took Timothy's life. Sleep deprivation. No clothes. Hot sauce. You heard the description of the hot sauce today. Oh no, that was Paul's idea. The hot sauce was Paul's idea. Paul's text to her. July 2nd, 3 days before Timothy dies. So apparently this hot sauce isn't just Carolina Reaper, it's also Trinidad Scorpion chili pepper. Her response, yep. She knew what it was. She went out of her way, whether it was her or whether it was Paul at her direction, or the two of them doing it together, out of her way to find a hot sauce that would be too much for him to take. Let's set aside the logic for just a moment that how is it that you decide you're going to punish a child with hot sauce
If the child likes hot sauce, it's ridiculous. That's the form of punishment? Of course not. That doesn't make any sense. Again, common sense. Don't check it at the door. He didn't like hot sauce. You know he didn't like hot sauce because they wouldn't be using it for a punishment if he liked it. This is July 2nd. This is weeks after this photograph is taken and sent to her when she can see how thin he is. Hot sauce. Hot sauce on bread. 4 slices with hot sauce. 4 slices, as long as there's plenty of hot sauce on it. Then if he waits 30 minutes, he can have some without hot sauce. So his reward for eating 4 slices of bread with hot sauce on it is if he can wait 30 minutes, he can have 4 regular pieces of bread. 30 seconds after she sends that text, she talks about getting chicken nuggets and fries for G. She can process all this in her head. Whoop, punishment, hot sauce, Timothy, whoop, fries, chicken nuggets for G. That doesn't sound like somebody who doesn't know what they're doing. That doesn't sound like somebody who has memory issues. That doesn't sound like somebody who's not in control of their actions. She's in control of everything. She is watching everything. She knows everything. Even when Paul is supposed to be watching. She's watching as well and critiquing how well Paul is doing watching. He's with Timothy at the tub, and she's watching to make sure that Timothy doesn't look too comfortable in the tub. Move his head. Looks like he's trying to get comfortable. Pour some cold water on him. Do the pizza roll thing. Somehow, as an act of grace, mercy, whatever you want to call it, go ahead and give him 2 pizza rolls, and I don't care if they're frozen. It's difficult to understand how a person can be so detached to another person, let alone a child. Ladies and gentlemen, it's the people's position in this case that the defendant is guilty of 2 crimes. That first crime is first-degree child abuse. In order to prove the crime of first-degree child abuse, I do have to prove the following. First, that Shanda Vander Ark is the parent of Timothy Ferguson. That goes obviously without question. Second, that the defendant either knowingly or intentionally caused serious harm and or serious mental harm to Timothy Ferguson. By serious physical harm, I mean any physical injury to a child that seriously impairs the child's health or physical well-being, including but not limited to brain damage, skull, bone fracture, subdural hematoma, subdural hemorrhage, dislocation, sprain, ankle, internal injury, poisoning, burn, scald, or severe cut. She killed him. She starved him to death. She directed that he be in an ice bath for hours at a time. And what was her story yesterday about the ice bath? Well, they didn't start off as ice baths. Okay, so they started off with cold water. No, they started off with hot water. Well, why would you put ice cubes in a hot bath? And how is that a punishment? Then confronted with the text, again, don't remember. Let him know that if he tries to sleep at all, sleep deprivation, he'll get another ice bath. There's been one before, sometime before you leave for work, and another when I get home. That's the description about 3 ice baths in one text message. I said, you wouldn't make up additional ice and put it in the freezer, would you? Because you needed it for later. No, we wouldn't do that. Might want to toss the ice that is made into some Ziploc bags in the freezer tomorrow, or if we need a bunch more. You heard Dr. DeYoung's testimony. Timothy had signs of hypothermia. How does a 15-year-old in Michigan in July get hypothermia? By sitting in an ice bath for hours upon hours upon hours at a time. And that's what Timothy went through on the last day of his life. Tortured with a pizza roll that he could eat. Cold water repeatedly dumped on him. Repositioned if he started to feel comfortable. And she's watching everything. She's directing everything. Serious mental harm. I mean, any injury to a child's mental condition that results in visible signs of an impairment of the child's judgment, behavior, ability to recognize reality, or ability to cope with the ordinary demands of life. That's a no-brainer. The level of mental harm inflicted on Timothy is difficult to grasp. Our 15-year-old, already with special needs, sensory, the sensory issue that she described, she's punishing him with hot sauce. She's punishing him with ice baths. She's punishing him with alarms that make noise that affects his ears. She's depriving him of sleep. She's depriving him of movement. She's depriving him of clothes. She's locking him in a closet. If that's not serious mental harm, then I don't know what is. And again, these are all at her direction. And don't let her off the hook, ladies and gentlemen, just because she stood up here and said yesterday, I didn't intend for these things to happen. Of course you intended for these things to happen. Of course you intended for these things to happen. She's guilty of first-degree child abuse. It's also the people's position that she's guilty of first-degree felony murder. If you find that she's guilty of that first-degree child abuse, you turn to the analysis of the murder charge here. And in order to prove first-degree murder, two sheets at once. First, that the defendant caused the death of Timothy Ferguson. That is, Timothy Ferguson died as a result of starvation and or physical abuse, physical neglect and abuse. You heard Dr. DeYoung's testimony about the cause of death for Timothy here, and all you needed to do was look at the photograph to see how he died. And again, I wish I could have spared everybody from seeing those photographs, but I can't, because I have to prove, and this is why, I have to prove how he died. The defendant has one of these three states of mind. She intended to kill, she intended to do great bodily harm to Timothy Ferguson, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. Let's talk about that first one for a moment. She intended to kill. I wish I could stand up here and tell you that I think she actually didn't have the intent to kill. I wish I could do that, because the notion that you could starve a child to death intentionally over months and months, which is what it would take, I wish she didn't have that intent. I wish I didn't believe that she had that intent. And it's for you to decide whether or not she had that intent, but her actions sure show that she had that intent. If she wanted to kill Timothy, I wish she'd done it a lot faster than what she did, because what he would have had to have gone through in those last few days or few weeks is unthinkable. But she had that intent to kill him. At a minimum, she had an intent to do him great bodily harm, and you can find either one. And even if you had struggled with finding that, she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. She made a situation so dangerous, so obviously dangerous to anyone, especially someone of her intelligence level, that death or great bodily harm was the likely result. Well, death was the result. Death was the result because of what she did to him, because of the things that she directed to be done to him. On the stand yesterday, she tried to say, well, some of this was Paul's idea. Paul did this, and Paul did that, and Paul did this, and Paul did that. If you need to, feel free to review these text messages. If you want, you can review the bigger binder of text messages, because these are all about Timothy as well. And when I say they're about Timothy, they're not about Timothy, all the good things that he's done, and all the good things we're going to do. It's all about the punishments. This is a small window. This is a larger window into the life, to the hell that Timothy's life was for the last 6 months. Every step of the way, her directing, her telling, her ordering, her threatening Paul to do the things. This was not on Paul. I told you in opening that you may not like Paul Ferguson. And I do believe that he is also in part responsible for Timothy's death here. But you had an opportunity to see Paul testify here. Did that look like the mastermind behind this? Or did that look like, as he put it, somebody who was just desperate for attention, desperate for the love of his mother, and doing the things that she wanted him to do? That's for you to decide. But I submit to you, ladies and gentlemen, that's what it was. That Paul was doing what she told him to do because he knew what was going to happen to him if he didn't do those things. Quite simply, ladies and gentlemen, as I've said, this is a case of first-degree felony murder. The underlying felony being first-degree child abuse. That's the other element that you need to find happened here, that she committed that felony first-degree child abuse. And if you find those two things, if you find that she committed the first-degree child abuse, and that she had one of those three states of mind, and it doesn't matter which one you decide, but if she had any one of those three states of mind as it related to Timothy, then she's guilty of first-degree felony murder, and she's guilty of first-degree child abuse. Ladies and gentlemen, Timothy Ferguson, to the defendant, had ceased to be a person. Timothy Ferguson had become less than the animals that she trains. You heard her say it would never occur to her to do the things that she did to Timothy to the animals that she trains, to the dogs that she trains. He was less than a dog to her. And this was a fight that he was not going to win. But don't take my word for it. Of course, I had it then. July 29th. And even if he sits up right before you get there, as you get there, I honestly don't care if you get a little rough with him. July 29th again. Trust me, I know he's thin. That being said, he told me a week and a half ago that he wanted to be thin to make me feel bad for punishing him. This is supposedly when he's on his hunger strike. You don't get to grump at him for that, though. I already let into him for it. Cleaning up the rooms, directing Paul to make sure that he cleans up the rooms. And please check the carpet to see if it needs to clean that too. There's some different awesome cleaner for the carpet that he can use if he needs to. He will need to use a different green and yellow sponge for that. I do not want him using my nice sponges for either of those. July 1st, after the photograph that she's got. Might be best if you give him like 4 pieces of bread to eat before he starts work, just to make sure he stands up while he eats them, please. That way he has no excuses. July 1st, the camera in his room needs to be picked up, please. Lots of hot sauce for that. What do I do if he doesn't finish within the assigned time? Hot sauce. These are all after that photograph. So apparently this hot sauce isn't just Carolina Reaper, it's the Trinidad Scorpion chili pepper. Yeah. While he's on a hunger strike on July 5th, the day before he dies. Forgot to tell you this before I left. Timothy was doing his fake stumbling and falling last night, of course, so I decided to prove once again how fake it is. I asked him if he would stop doing that, if he would eat a whole pizza by himself, and he said yes, of course. And then I told him how obvious it was that he was being fake, and he had just proven that yet again, and of course he just looked down and didn't respond. Can't say it any more blunt than she does. she was not going to let Timothy win. Plain and simple. And if that many died, the many died. He dies, she kicks into survival mode and starts to lie to the police. That alone evidences a guilty state of mind, ladies and gentlemen, but you don't need that. You don't need much more than these text messages to prove that Shanda Vander Ark is responsible because she intended to kill, because she intended to do great bodily harm, or she at least created a situation so dangerous that death or great bodily harm was a result to her child, Timothy Ferguson. And I will ask you to return a verdict of guilty of first-degree felony murder, first-degree child abuse. Thank you.
Mr. Roberts. Mr. Johnson.
Thank you, Your Honor.
Good afternoon, ladies and gentlemen. All right. Everybody ready? Need a moment? You all good? Okay. I'm a child of the late 50s and grew up in the 60s and 70s, and during that period of time, and even the 80s and 90s, when you remember something, it was in your head. It was something that was up here, and a memory was up there, and that's where the memories were. That's where we kept them, and it was a great system because they were all there, and if called upon to respond to a memory, a situation, an issue, the entire memory and its context would come coming out. Then we started doing something in the aughts and the 10s and the 20s, where we started having these devices called cellular phones. And in those cellular phones, they have this thing on them called text messaging, where you can write down whatever's going through your head at the moment and send it. It's a great system. I mean, let's face it, we all use it because it works, and it works well, and it's very utilitarian, and we love it. But I think if we had a chance to think about it, we'd all admit that what you text isn't everything that's going on. That what you text doesn't tell the whole story. The text you sent today don't tell the whole story of your whole day. Just tell a portion of it. They tell a snippet. They tell a story, but they probably don't tell what happened to you from the time you got up and you couldn't find your left shoe to the time you're going to go to sleep tonight and wishing you'd had an extra slice of that pie for dessert. It doesn't tell you all that stuff, right? It tells you a snippet. It tells you a bit. It doesn't tell if you're mad or you're kidding or you're suggesting or you're tired or you didn't spell check before you sent it. So it says go when you want to say goat. It doesn't tell any of that stuff. It tells you a snippet. It tells you a portion. It tells you a particle. And that's what text messages do. The greatness of text messages are they're great. It's in the message. The weakness of them is they don't tell the whole story. And if someone were to grab someone's phone and look at what they did from a year and a half ago and try to figure out what they were thinking based on their text, they'd know that snippet, but they wouldn't know I'm venting. They wouldn't know. I don't take this serious. I don't mean this seriously. They wouldn't know that even though I'm mad at you, I still love you, because that's the part in the text is going to be, you didn't clean your room, and that's it, because that other part isn't with it. The other part, our communication, even when I speak to you right now, our communication is the words that come out of my mouth are only about 35% of what information you're taking in. You're watching my body language. You're listening to the sound of my voice. You're listening to the context. You're looking at the situation. That fills in the other information that you're going to need to have in order to figure out, with the most powerful computers that known to man, our brains, what I really mean and what I'm really saying. If you have all you have is a text, ladies and gentlemen, it's like watching a movie with no picture. All you hear is the voices in the background. Somebody has to explain to you what else is going on in that scene. That's what we have here. We have a series of texts. We have a series of texts that people can select and jump around in terms of not just times and dates and times of day and without reflection on the circumstances, you're at work, you have time to send a 3-second text before the judge calls you and says, come do something else. Or you're sitting in your living room, you're reading a book, and you can take your time with these texts. It doesn't tell you any of that. So what comes out to you is a distorted picture. My suggestion, someone takes your text, what comes out to you is a distorted picture. It's not the whole story. It's not the whole situation. It doesn't tell the whole thing. All the texts that you've written do not tell you the whole story of your life. It tells you what they refer to that moment, and that's it. And the rest has to be inferred. If someone comes along and takes it out of context, and takes it out of circumstances, and it takes it out of where it existed at the time you sent it, you have a different story than what was intended. The communication you're getting is different than what you intended. That's problem number one. Problem number two is when you take those texts and you back them up with somebody who's highly motivated to lie. Ladies and gentlemen, they didn't have supercomputers back when they invented the theory of relativity. When Einstein, he didn't have a supercomputer. They hadn't been invented yet. What Einstein used to do famously, he used to call them thought experiments, where he'd imagine a situation and then he tried to think his way through. He was pretty good at it. He kind of changed life on the planet doing this. He kind of changed life on the planet. Now, you've been told that Paul's deal was that he had immunity from prosecution for whatever he talked about, and he'd get a sentencing recommendation or something like that. And there was one other thing, I forget, it doesn't matter. There's 3 things you were told him. He's charged with child endangerment, child abuse in the 1st degree. Okay. And you were told that by our judge that you can believe all of what somebody says, part of what somebody says, or none of what somebody says. You were told that was Paul's deal. I'm going to invite you to do it. And that Paul could be charged with 1st degree murder, which Paul told you from the stand. I asked him, do you know what the penalty for that is? I sure do. He could be charged with 1st degree. Now, I want you to do this thought experiment. You're a lawyer. You're Paul's lawyer in this thought experiment of my making. And the prosecutor calls you and say, I want to use your client to testify against his mom. And you say, okay. And then you have the client testify. And then he testifies. He does everything he's required to do, everything he wants. They want it. He gives them everything he could. He gives them. And then at the end, once he's done testifying, his lawyer finds out they've charged his client with 1st degree murder anyway. After all, that wasn't part of the deal, right? He could be charged with 1st degree murder. Paul could be, theoretically, it's not part of the deal, could be charged with 1st degree murder, even though he's fully performed. What would, in this thought experiment, what would your reaction be? That you sent your client in, he did everything he was told, and he still gets charged with 1st degree murder. Might I suggest to you that you might be a little upset with that? Might I suggest to you that if you were informed that after Paul has performed and you're his lawyer and he's still getting charged with 1st degree murder, that you're going to be upset? And I further suggest that you're going to tell everybody, you're going to tell all of your defense friends, all your defense lawyers, you're going to tell them, this is what they did to me. When do you think the prosecutor is going to get another defense attorney to serve their client up again? If you do that, when do you think they're going to get another defense attorney in this county and your thought experiment to serve up their client if he does what he's supposed to do and he still gets charged in the circumstances like we described? Well, you know what the answer is. You know what the answer is. In your thought experiment, you can figure out this is what is not going to happen. Because you know what's going to happen with the defense community is going to find out what happened with Paul and his testimony. Get what he's supposed to, still got charged with 1st degree murder. Get what he's supposed to. He's not going to be able to get, the prosecution is not going to get another defense attorney to come forward and give up their client again. This is part of something that's obvious, and it doesn't have to be in writing. Everybody, if you do the thought experiment, it's in writing. It's not in writing, but you can do the thought experiment. You can bet your house Paul's not going to get charged for first-degree murder. You can bet your house that Paul's deal is not his immunity. Paul's deal is that no first-degree murder. That's his deal. Paul is highly motivated to tell you the story that will keep him from getting that charge. And he did. Read his own text. Paul's the one who's talking about, I wish I could beat him up. I've never wanted to beat up somebody more in my life. Paul's the one who kicked in the door. Paul's the tormentor. Paul is the guy who's not only tormenting his brother, he's also enjoying it. And Paul is motivated to say now, and Paul testified against his mom. Paul tortured his brother. That's who Paul is. And Paul ain't gonna be charged with first-degree murder. I don't care what the deal is. I think that should be obvious. So you got the two bigs. You've got these text messages that give you a false and misleading representation of what people are thinking. You've got Paul sitting here talking for his life, talking his butt off. He's trying to get out from under. In fact, at one point I asked him, "Isn't a 2-year-old a letter to your mom saying you wish it just ended all so you could get out of this thing?" And he said, "Yes, I did." That's who Paul is. Paul's also the nexus of information for my client. Yes, my client, he told my client one time that he thinks he's thin, we should feed him, but on another time, in fact, right before his death, Paul says, no, he's fine. Paul is the nexus of information. If you have those cameras, these security cameras in your home, you recognize those are great devices. And generally speaking, they do the job. But the kind of detail, the kind of vision that you need, you really need Paul there to augment that so that you get a full picture of what's going on. And Paul was there, and he was providing for my client. Third factor. I got a client that forgot everything. She forgot her name, if you were asking. She forgot everything, just basically. Okay. When Mr. Roberts was given his open, and quite frankly, I've been doing this for 35 years. That's one of the finest openings I've ever heard. It was just wonderful. It was those kinds of things that lawyers appreciate because it was so well crafted, so well delivered. And he even gave you some poetry, and I'm no poet. I can't match that. I look for stuff, but I can't find anything like he did. It was just a wonderful opening. What I got for you is a little bit of physics. 20 years ago, 30 maybe, I read that the smallest bit of matter theoretically possible to exist in the universe would be about 2/100,000th of a billionth of a millimeter. And it would be a thing. It'd be two-dimensional. It'd be a thing that's so high energy that it could only exist for a brief moment in time. It exists and it pops out of existence. I read that 30 years ago. I couldn't tell you the first name or last name of any people in this panel right now. It's not because it's not important. It's because that's the way memory works. I couldn't tell. That's the way memory works. It is not a logical construct where you remember things that you're supposed to, but you can forget the things you don't. Memory remembers what it wants to remember. Now you can do techniques and training to do, and if something is someone that causes a lot of adrenaline or something that burns the memory into you, you remember that. You remember when your child was born, because that's the sort of situation it is. But otherwise, memory has its own mind, and it remembers what it wants and it forgets what it wants. And to say, well, she didn't remember these things. Well, yeah, she probably doesn't. You know, we talked about, and to use Mr. Roberts' example. At one moment, my client is talking about getting fries for the younger child, but getting hot sauce for the older child. And he talks about compartmentalizing. The brain is a sophisticated organism, it's a sophisticated panel. It will organize things according to whatever parameters that are there, but it will separate things out. And it is my argument. The argument we made from the very beginning is that while part of her knew she was punishing this boy, none of her knew that she was hurting him. I understand. There's two possibilities. One, she's exactly what Mr. Roberts said, and that's evil. That's evil. Or the other possibility is there's something going on and she doesn't understand. She didn't understand, despite all the intelligence, she didn't understand the ultimate consequence of those individual acts of punishment. The accumulated force and power and weight of those individual acts of punishment. She didn't understand it. She didn't see it. I don't know how that could be, but to be honest with you, that's what makes sense. It makes sense because this is her son. And there would be, and she raised other children, her own flesh and blood. She raised them and didn't do this sorts of things to them. Something was going on where she didn't understand it. This child was probably the highest needs. She didn't understand it. And her personal situation also makes a difference. Look, she took this child in when she wasn't supposed to have him because there was no other choice. So she did it. She raised another child. Paul has special. Paul's 20 years old and living at home with mom and working minimum wage. This is what Paul's doing. She has other child, and she has the demands of judges and lawyers, and she has the demands of education and the demands of ambitions, and her husband gets a stroke. These all make a difference. That's what I'm talking about context. Giving 4 slices of bread with hot sauce on it doesn't talk about she's thinking about her husband, the impact is how she's gonna pay the rent, how she's gonna get to work tomorrow. There's no gas in the car. These are all things that are going. There isn't a situation where she's sitting there just thinking about this one problem. She has too many problems to think about one. She's thinking about them all at a time. And pressure busts a pipe. It was too much. She didn't hate her child. That's what it would have taken to knowingly do this to your child. She would have to hate him. A child makes you angry. A child makes you frustrated. A child makes you tired. A child is willful. And and she wasn't able to cope with it. And she didn't add it up. The bread plus the water plus the standing against the wall. She didn't add it up. And the mind is a powerful thing. She didn't see what we all saw. But let me. So this woman who doesn't love her son, according to the people, comes into a room and she says, "Timothy, please, no. Wake up. Come on, buddy. No. This can't happen. Is he okay? Is he okay? He's not stiff. Please, baby, come on. Open his jaw for me. Please, come on. Come on, buddy. You're okay. Come on, buddy. Come on, Timothy. I don't understand." To which Paul says, "I don't either. Come on, buddy. Come on, sweetie. Come on, buddy. Come back to us. Come on, buddy. Come on, buddy. Come on." Does she get scared of that? Yep. And like, please. Hell yeah. She does. A lot. Because like Paul, she can see it now. Now, she doesn't have to do the math. The math is the body of her dead son. And they can both see it now. But as they were going through it, folks, they didn't see it. I don't think at the moment that they find the body and they says, I don't understand it. Paul says, I don't either. They were faking it for the camera or faking it for the police. They forgot all about the damn camera. They said those things because that was true. It's what you do in those moments of high stress. It's true. I didn't get this. I didn't see this coming. How could you not? They didn't. They didn't see it. Neither one of them saw it. Paul talked about, in his few moments of clarity, I love my brother. I wish it was me instead of him. And that's how, did he start feeling that way afterward? Or did he feel that way at the time? If he felt that way at the time, how could he do these things? Because he didn't know he was doing these things. You see where I'm going? How could he feel? I repeat, he said he'd give his life for his brother if he could. Question is, did he feel that way at the time he was doing these things to him? Well, how could he do those things to him if he felt that way? Because they didn't see it. These people committed manslaughter. That's what they did. It caused this boy's death, but they didn't intend it. That's simply it. We're asking that you, when you do your deliberations, that you consider that. I understand those pictures look like. I understand they look like. I understand that everybody here wants justice for Timothy. I get that too. Justice is the conviction of a person for what they did, not for what they made us angry about, not what they made us sick about, not what they made us want to jump over that railing and take care of this thing ourselves. That's not what justice is. Justice is, this is what you did, and this is what you pay for. Thank you, ladies and gentlemen.
Mr. Roberts.
Thank you, ladies and gentlemen. Because I do bear the burden of proof in this case, I do get one more opportunity to address you. And I want to start by thanking Mr. Johnson for his compliments here. We tried a number of cases together over the years, and it's always, quite frankly, it's always a pleasure to work with Mr. Johnson. And I think a lot of folks are probably confused sometimes when they see a relationship, a good relationship between both sides. And what I always tell people is this is an adversarial system by its nature, but that doesn't mean that the parties necessarily have to be adversaries. We don't have to agree on everything, and ultimately, that's why you folks are here. Let's start with Mr. Johnson's comments about the text messages and how text messages don't show all of what a person is doing. He's right. They don't show all of what a person is doing or necessarily even what a person is thinking, but they do offer a window into the insight of what a person is thinking about. They do offer a window into what a person is telling somebody else to do or telling somebody else to say. So the fact that there are that binder full of text messages over a 6-month period about what to do to punish Timothy offers you a window into the inside of the defendant. But actions are what speaks louder than words here. Because everything that she talked about, everything that she wanted to have done, with the exception of one thing, so out of bounds, I can't even believe she posed it, but everything that she wanted to have done was done. That's not text messages, that's her actions. Her actions, not her text messages, caused Timothy's death. Her actions, not her text messages, caused Timothy to suffer serious emotional, mental, and physical harm that resulted in his death. Withhold the food. Give him bread with hot sauce. Put him in an ice bath. Make sure he doesn't sleep. Make sure all the food is locked up. Make him run the stairs. It goes on and on and on and on. Her actions speak louder than her words. Mr. Johnson talked to you about Paul. And I'll leave you to your recollection of what Paul's deal was, but Mr. Johnson summarized it fairly well. There is not an agreement in place that Paul is not charged with murder in this case. Ultimately, that's a decision that our office gets to make. So he wants you to look at Paul's testimony through that lens. Go ahead. Please do. What did Paul lie about? What did Paul get on the stand and tell you that wasn't true? What did Paul get up there and describe what he had done to Timothy at Shanda's direction that didn't happen? Nothing. Mr. Johnson cited nothing for you to look at in Paul's testimony that wasn't true. And he can't, because everything Paul talked about that he did is verified by the text messages. Every single one of them. And again, the only thing he didn't do, and he's the one that drew the line, the only thing he didn't do was when the day before her child dies, as she's looking at him in an ice bath for hours upon end, and says, hey, crazy idea. What would it feel like if hot sauce was poured on your private parts? I'm not saying touch him there or anything, but what do you think? Are you kidding me? That's why I said yesterday, did you even need to ask that question? What do you think? That's what's in her mind. That's how you determine what her intent is. That's what the instructions are going to tell you to do. This isn't a tiny glimpse of her. This isn't a tiny moment in time, and you can't assume that that's what she is. You can assume that's what she has done for the last 6 months. Because that's what this is about. That's what these text messages are about. Every single one of them. Right up until the very end. The last thing she says to Paul before they find Timothy that next morning is, I had to drag him back into the small room. He decided to go big or go home today. The last thing she says to her child, you don't have to breathe with your mouth open, dummy. Her actions, what makes her guilty? The text messages are just evidence to support the actions that she took. Paul aided and abetted in the death of his brother. There's no question about that. He did these things. But you saw Paul. You heard him talk about what limitations he has. You heard him talk about what type of person he was. But you know what Paul is not? Paul is not Timothy's father. Paul is not the person charged with the care and custody and love of his brother. He can love him. And as he said, I guess I didn't love him enough. It's up to you whether you believe that was genuine or not. But even if you believe it wasn't, even if you believe his emotion about this and his remorse about this is fake, he didn't lie about anything else. It's all proven. And let's just assume, for the sake of argument, that Paul is the mastermind behind all of this. Paul's responsible for everything. Why do you leave him alone with him? If you're the parent, why are you leaving your child alone with somebody who's this monstrous? It doesn't make any sense. The reason Paul is left to watch over him is because Shanda can manipulate Paul into doing the things that she needs to have done. She knew she had somebody in Paul that would carry out her instructions implicitly. I'm glad she stopped Paul from being physical with Timothy. I am. I appreciate that the one thing he did not actually have to suffer as a result of this were beatings. But everything else was just to isolate Timothy from the world. Look at the lengths she went to make sure that the grandmother of the youngest child couldn't come to the home, to the point where she's tracking her on her phone when she's driving home from work. Now, I don't like it when my in-laws come over and my house is dirty, but I'm not looking at my phone to see when they're going to get here or make sure I meet them outside so they don't come inside. You only do that because you're trying to hide something. What is she trying to hide? She's trying to hide Timothy. Because anybody that would have seen Timothy, anybody that looked at that child would have known what was going on. And she couldn't have that. And her mind is working well enough to know, I can't have people seeing Timothy. I can't have photographs of Timothy. I need to have Paul do these things. I need to make sure that Timothy doesn't get to go outside. Did you hear her say anything about anywhere that Timothy got to go? The closest she came to saying, well, the backyard is kind of open and you can kind of see in the backyard. She talked about taking him to Craig's Cruisers or taking him to a movie or taking him to a restaurant, any of that stuff? No. Timothy was a prisoner, treated lower than a human, treated lower than an animal in his own home. A prisoner in his own home. The 911 call. She said all those things. You heard all those things. I'll leave it to you to determine whether or not the emotion that she's displaying there was real. Sounds cold. Yeah, she's upset. She's upset that he's dead. But if you're so worried, if you're so concerned, if you're so alarmed, if you care so much about this person, why do you wait 18 minutes to call 911? Why, when your son, who's 20 years old, says to you, I think we need to call an ambulance, or should we call an ambulance? You say, no, not yet. Not yet? Not yet? When? When you're done making it sure, like, you're covering up as much evidence as possible? Because that's when. Because then it becomes a matter of making sure he's got pants on and put your belt on to make sure he looks, that he's looked this way. Make sure we tell him he was on a hunger strike. And now I guess we'll have to call 911. Not yet. Don't call 911 yet. What are you waiting for? Got to get the story straight. Guess I'm going to be late for work. You heard Paul up here yesterday say that he'd trade places with Timothy if he could. Did you hear the defendant say that? No. Mr. Johnson said she had so many things on her mind. It was just, this was just one thing too many. He's right. Timothy was the one thing too many. Timothy was too much for her. And as a result, she decided she wasn't going to lose this fight. Timothy was too much for her to handle, but she was going to win. And again, don't take my word for it. February 16th, 5 months before Timothy dies. I may need some help with it, but I'm about to get a lock for the pantry door. Remember what she said about the pantry? And a lock for the fridge and both freezers, and then we won't leave any food out in those areas, and he won't have access to unlock those. This is supposedly February 14th. This is when he's on a hunger strike because of Adam's stroke, right? So your child's on a hunger strike and you're locking away the food? Paul's response, okay. If you disagree, please say so, but he is not going to win this. There it is, ladies and gentlemen. She was bound and determined that she was going to win. Timothy was no longer a human to her. Timothy was something even below the dogs that she trained, but she was going to make sure that she won this fight. Ladies and gentlemen, it is now up to you to send a message to her that she lost this fight. Thank you.
All right, thank you, Mr. Roberts. Yes. Good. Okay. Well, Mr. Is that you use the restroom?
No, sir.
Okay. All right. All right. Members of the jury, the evidence and the arguments in this case have finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and a just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and the testimony and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If the lawyer says something different about the law, follow what I say. At various times, I have given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and then ignore others. To sum up, it's your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way decide this case. As I've repeatedly said, a person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of a crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair and honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or a possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you decide this case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything that I have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. The lawyer's question to witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answers. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give instructions, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, national origin of the witness. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about the following questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that may have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does a witness's age and maturity affect how you judge his or her testimony? Does a witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does a witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proven by direct evidence from what a witness or exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you were to look outside and see rain falling, that would be direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So in my example, if you were to see a person come in from the outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You have heard evidence that before the trial, a witness made a statement that may be inconsistent with her testimony or his testimony here in court. You may consider an inconsistent statement made before the trial to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth or of whatever the witness said in the earlier statement when determining the facts of this case. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that she meant to do so. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and the evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer or a lawyer's representative talked to one of the witnesses. There's nothing wrong with this. A lawyer or lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You have also heard testimony from a witness, Dr. Joyce DeYoung, who has given you her opinion as an expert in the field of forensic pathology. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's testimony or opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts she gave for her opinion and whether those facts are true. You should also think about the expert's qualifications and whether her opinion makes sense when you think about the other evidence in this case. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards as used to evaluate the testimony of any other witness. The defendant is charged with counts, that is, with the separate crimes of homicide, open murder, and first-degree child abuse. These are separate crimes, and the prosecutor is charging that the defendant committed all of them. You must consider each crime separately in light of all the evidence in the case. The defendant is charged with first-degree felony murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Timothy Ferguson. That is, that Timothy Ferguson died as a result of starvation and/or physical neglect and abuse. Second, that the defendant had one of these three states of mind. she intended to kill, or she intended to do great bodily harm to Timothy Ferguson, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. Third, that when she did the act that caused the death of Timothy Ferguson, the defendant was committing or attempting to commit or helping someone else commit the crime of first-degree child abuse. For the first-degree, the elements of the first-degree child abuse must be proven by the prosecutor beyond a reasonable doubt, and those elements include the following. First, that Shanda Vander Ark is the parent of Timothy Ferguson. Second, that the defendant either knowingly or intentionally caused serious physical harm and or serious mental harm to Timothy Ferguson. Third, that Timothy Ferguson was at the time under the age of 18. By serious physical harm, I mean any physical injury to a child that seriously impairs the child's health or physical well-being, including but not limited to brain damage, a skull or bone fracture, subdural hemorrhage or hematoma, dislocation, sprain, internal injury, poisoning, burn, or scald or severe cut. By serious mental harm, I mean an injury to a child's mental condition that results in visible signs of an impairment in the child's judgment, behavior, ability to recognize reality, or ability to cope with the ordinary demands of life. The fourth element of first-degree felony murder is that the killing was not justified, excused, or done under circumstances that would reduce it to a lesser crime. Determining whether the act causing death occurred while the defendant was committing or attempting to commit or helping someone else commit the crime of first-degree child abuse, you should consider the following. One, the length of time between the commission of first-degree child abuse and the murder. Second, the distance between the scene of the first-degree child abuse and the scene of the murder. Third, whether there is a causal connection between the murder and first-degree child abuse. Fourth, whether there's a continuity of action between first-degree child abuse and the murder. Fifth, whether the murder was committed during an attempt to escape. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Timothy Ferguson. That is, that Timothy Ferguson died as a result of starvation and or physical neglect and abuse. Second, that the defendant had one of these three states of mind. She intended to kill, or she intended to do great bodily harm to Timothy Ferguson, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. Third, that the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. You may also consider the lesser charge of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Timothy Ferguson. That is, that Timothy Ferguson died as a result of starvation and or physical neglect and abuse. Second, in doing the act that caused Timothy Ferguson's death, the defendant acted in a grossly negligent manner. Gross negligence means more than carelessness. It means willfully disregarding the result to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, she knew there was a situation that required her to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be a serious injury. The defendant is also charged with the crime of first-degree child abuse. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that Shanda Vander Ark is the parent of Timothy Ferguson. Second, that the defendant either knowingly or intentionally caused serious physical harm and or serious mental harm to Timothy Ferguson. By serious physical harm, I mean any physical injury to a child that seriously impairs a child's health or physical well-being, including but not limited to brain damage, a skull or bone fracture, subdural hemorrhage or hematoma, dislocation, sprain, internal injury, poisoning, burn or scald, or severe cut. By serious mental harm, I mean an injury to a child's mental condition that results in visible signs of an impairment in the child's judgment, behavior, ability to recognize reality, or ability to cope with the ordinary demands of life. Third, that Timothy Ferguson was at the time under the age of 18. It's not a crime to discipline a child. A parent may use force to discipline a child, but this does not mean that any amount of force may be used. The law permits only such force as is reasonable. The defendant is not required to prove that the acts alleged here were reasonable. The prosecutor must prove beyond a reasonable doubt that the force used was not reasonable as discipline. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts and circumstances and evidence. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. In this case, the defendant is charged with committing open murder and first-degree child abuse, or intentionally assisting someone else in committing it. Anyone who intentionally insists someone in committing a crime is as guilty as the person who directly commits it, and can be convicted of that crime as an aider and abetter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the alleged crime was actually committed either by the defendant or someone else. It does not matter whether anyone else has been convicted of that crime. Second, that before or during that crime, the defendant did something to assist, counsel, aid, or abet the commission of the crime. Third, at the time the defendant must have intended the commission of the crime alleged, or must have known that the other person intended its commission, or that the crime alleged was a natural and probable consequence of the commission of the crime intended. It does not matter how much help, advice, or encouragement the defendant gave. However, you must decide whether the defendant intended to help another commit the crime and whether her help, advice, or encouragement actually did help, advise, or encourage the crime. The evidence must convince you beyond a reasonable doubt that the crime occurred on or about July 6, 2022 within Muskegon County. When you go to the jury room, you will be provided with a written copy of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is not necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own individual mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk to each other and make every reasonable effort to reach an agreement. Express your opinions and the reason for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide that you were wrong. Try to work out your differences. However, although you should try to reach an agreement, none of you should give up your own honest opinion about the case just because the other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any question about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing to the bailiff. Possible penalties should not influence your decision. It's the duty of the judge to fix the penalty within the limits provided by the law. If you have any questions or wish to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It's not proper for you to talk directly to the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you are permitted to take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, you simply need to ask for them.
I think after they do, I'm almost sure after they do the jury instructions, of course, they go back and they do their deliberations, right? So let's see if we can find, let me get her verdict up. I wonder how she looked when they gave her the verdict. Wait a minute. Let me get the verdict up. And then once we get the verdict up, then we'll go into the sentencing for Paul. We can see about the sentencing for Paul. Let's see. Let me see if it's in my little playlist. Oh, okay, yeah, jury deliberating. Let me see. How long was they deliberating? I don't look like it was long, y'all.
Vander Ark. The court
Like
has
50
been
minutes? Dang. It looked like they only deliberated for like 50 minutes, y'all. I shit you not. Like, wow. No, no, y'all can tell me if y'all find something that shows longer, but I just see 50 minutes. They weren't even back there an hour.
You may be seated. All right, we are back in the record in file 23110 FC, People versus Shanda Vander Ark. The court has been informed the jury has reached a verdict. Mr. Johnson, Ms. Vander Ark is not present. My understanding is you had an opportunity to speak with her and discuss her presence today. Is that correct?
That's correct, Your Honor. That's where I've been since our last adjournment. So I just came up with her. She's declined to join us for this portion of the trial.
Okay. During the break, I anticipated that, and I did a little case law research. There is no law in the state of Michigan at this time that requires the defendant to be present for the verdict. There is a law that does require her to be here for sentencing and hear the victim statements, but so the court was essentially left with a choice of forcibly compelling her to be here, which could cause her to, I don't know, could cause further issues. We have deputies that certainly, if I order them to do that, they would do that, but I don't want to put them in a position of harm if something happens, and I don't think that's appropriate. So I'm not going to do that. And again, there is no law that requires her to do that. So, Mr. Roberts, anything for the record before we bring the jury out?
Your Honor, I would concur with the court's research here. I think that we're all aware that there was a law recently passed that requires the defendant to be present for at least the victim impact portion of sentencing, and I agree. I don't think there's anything that requires her to be here. So pursuant to the written stipulation that she has already filed and has been witnessed and updated by Mr. Johnson as we go here, I think we'll proceed without her presence.
Okay. Anything else, Mr. Johnson, before we leave again?
No, sir.
All right, please rise. You may be seated. All right, ladies and gentlemen, the court has been informed that you have reached a verdict. If that is true, I'd have the foreman please rise and give the verdict form to Mr. Weaver, the bailiff. All right, thank you, Mr. Weaver. Can the foreperson please rise and announce the verdict?
She has to read the whole thing, or?
Typically, there's no set way to do it, but typically you could say in the people of the state of Michigan versus, and then on one count, what the verdict is, and count two.
And the people of the United States versus Shanda Vander Ark, count one.
You mean people of the state of Michigan, correct?
Oh, I'm sorry.
Yep.
I apologize.
Okay, all right, that's
The
okay.
people of the state of Michigan versus Shanda Vander Ark, count 1, charging open murder involving the death of Timothy Ferguson. We find her guilty of first-degree felony murder. Count 2, first-degree child abuse. We find her guilty of first-degree child abuse.
All right, thank you. Thank you. Court will record the verdict for the record. Mr. Johnson, would you like the jury poll?
Please.
All right. All right, juror number 2, please rise. And is that your verdict?
Yes, sir.
Juror number 5, no, excuse me, 4, is that your verdict? Okay, and you don't have to say, you can say yes or no. So juror number, actually that was juror number 4. Juror number 5, is that your verdict?
Yes.
All right, you can sit down. Juror number 6, please rise. Is that your verdict?
Yes, sir.
All right, juror number 7, is that your verdict?
Yes.
All right, juror number 8, is that your verdict?
Yes.
Juror number 9, is that your verdict?
Yes.
Juror number 10, is that your verdict?
Yes.
Juror number 11, is that your verdict?
Yes, Your Honor.
Juror number 12, is that your verdict?
Yes.
Juror number 13, is that your verdict?
Yes.
And juror number 14, is that your verdict?
Yes.
All right. So with that being said, again, the court will record the verdict for the record. Ladies and gentlemen, I thank you for your service. This was an incredibly difficult case. Now, you know, when the attorneys were discussing what the evidence would be, I think you understand what we were talking about. Unfortunately, now it was not for the faint of heart, and certainly those of you who did this, unfortunately, it's unfortunate that you will not get those images out of your mind. I won't, but somebody had to do it, and I'm glad that you were willing to do that. You are discharged of service at this time. You are free to talk to anyone you wish about this, or you don't have to talk to anybody if you don't want to, but you're free. Restriction regarding news reports, you can do anything you want. You can talk to anyone you want at this point going forward. So again, thank you for your service, and you are excused. Mr. Weaver, please rise.
Okay, so I'm gonna pull up our sentencing so we can go right into the sentencing. When I go into the sentencing, I'm also gonna put up something I need to see. I wanted to find out y'all what y'all thought about, what y'all think about. I seen this. I don't know if we should do anything with this case or not. I'm gonna put a poll up and y'all tell me if y'all have heard of it, and if we should be planning on doing something with it. I'm not sure. Wait a minute. You gotta definitely see her do a walk of shame. Oh, no problem. You know, it's my pleasure. Let me see. Here she goes. Wobble, wobble. Wobble, wobble. Wobble, wobble. No, this is sentencing right now. We just watched the verdict, SD.
Okay. Nothing to see.
We are on the record in file 23110FC. It's people of the state of Michigan versus Shanda Vander Ark. Are you Shanda Vander Ark?
Yes, sir.
All right, Ms. Vander Ark appears before the court with her attorney, Mr. Fred Johnson. The people are represented by Matt Roberts. The date and time scheduled for a sentencing in this case. Have the people had a chance to read the pre-sentence report and the attached guidelines?
We have, Your Honor, we have no additions or corrections, although I have been advised by Mr. Johnson that he does have a number of corrections. We've discussed those over email. And but for his objection to the restitution award, we have no objection to the corrections that he's seeking.
Okay, I did get an email from Mr. Johnson. I appreciate that. Why don't we just go through each objection just to make sure we have them all on the record, and then we'll inquire to Mr. Roberts whether or not he objects to that. So you may
Thank you,
proceed.
Your Honor. May we start with the very first page one, the first page one?
Okay.
As I noted, under the personal history information, it notes that my client's educational attainment has been a bachelor's degree. We're asking the court strike that and insert the words Juris Doctorate.
Any objection, Mr. Roberts?
No objection, Judge.
Okay. And then just
Wanna
for
make sure y'all got
probation
that
notes,
doctor in here.
I'll
Don't be trying
Ms.
to play
Anderson, I will send you, did you get a copy of the email?
I did not, Your Honor.
All right, I'll forward that to you just so you'll have it in writing exactly what all the corrections are. So, all right, go ahead, Mr. Johnson.
On page 2, the very next page, at the under the rubric jail credit, it indicates that the dates that we're in question here are in July 7th, 2022 to January 19th, 2024. And we're asking the court to amend that to today's date, the second date, January 23rd, 2024.
Any objection, Mr. Roberts?
That checks out, Judge. That'd be 4 additional days, so 575 days of credit.
Okay.
That's
I'll
our
change it.
position. Well, thank you. Let's see here. Make sure I don't miss anyone. Judge, on page 2 of the interior of the document, the second page 2, on the let's see, 1, 2, third paragraph down, there's a request for restitution for $5,000 to the Michigan Department of Health and Human Services. We object to that request. We ask that the court disallow that request at this juncture. We haven't received any information to justify it, and we'd ask for a hearing if the court plans to proceed on that.
Mr. Roberts?
Your Honor, that request is made by the Department of Health and Human Services as compensation back to the Crime Victims' Rights Compensation Act. That fund did pay out some funeral expenses as a result of this, and the fund is entitled to seek compensation from the defendant in those cases. I think it would end up being joint and severally liable with Paul Ferguson as well if we get to that juncture with Paul Ferguson. But we do believe it is an appropriate award, and there is documentation from the state to indicate that that award was paid out. So we would request that $5,000 be ordered.
Has Mr. Johnson been provided that documentation?
He may not have. I can forward those to him. So.
Mr. Johnson, would you prefer to just have the restitution portion reserved until you can receive the documentation? Then if you so choose, you can ask for a restitution hearing. I guess what would your preference be, or Mr. Roberts, what your preference would be? I mean, I can order it with the ability for Mr. Johnson to come in and ask for a hearing, but I guess it depends on what either one you would like to do.
If I could just make a suggestion, I would prefer that in lieu of that, the only other thing I would ask that is if I can get the information to Mr. Johnson, my understanding is Ms. Vander Ark has another matter which is being handled in front of a different judge at this time. That case is not going to finish today, and she will be here at least until tomorrow. But perhaps by then we can work out this restitution issue and just move forward that way with the court ordering it. And then if Mr. Johnson chose at a later time to challenge it, certainly he would have the right to do that through a motion.
Okay, yeah, what I'll do is, I mean, I think the paragraph in there saying that the requesting restitution, I don't think there's any need to strike that in terms of ordering it. What I'll do is I'm going to order it with your opportunity, Mr. Johnson, to request a hearing. And obviously, if you want a hearing, we'll have a hearing on it. And if you don't, then it'll stand as ordered.
Thank you, Your Honor.
I'll provide Mr. Johnson the documentation we have as well. So
I know.
he can review that, Judge.
Okay, you can continue, Mr. Johnson.
Page 3, Judge, and this first one was not in the email that I sent to the court. This is one I was able to identify later on, and it's in the very first sentence. The first sentence reads, "It is therefore recommended." I think there was intention that the words "there" and "for" be combined into "therefore." Okay. To make that correction.
Objection, Mr. Roberts?
No objection.
All right.
On the third paragraph, under description of offense narrative, in the last line of the third paragraph, there were visible bruised on his chest. I believe it ought to have been bruises on his chest, and we'd ask to make that correction.
Okay, no objection.
On page, if the court will go forward to page 5.
All right.
Let's see, 1, 2, 3, 4, 5. Paragraph 6. there's a description of the plea negotiation for Paul Ferguson there. And while we don't object to what's stated, we would like to add language that, in addition to what's stated, that the people have agreed to fairly and fully inform the court. And I think that was testified to as part of the agreement.
That is accurate, Judge, so no objection to that.
Okay. Okay. On page 7, under the heading of employment, under unemployed, then it says 17th Circuit Court. I believe the intention was to say 27th Circuit Court, Your Honor. That's where the employment was, in fact.
Yeah, I did see that. I think the 17th is actually Kent County, I believe. So it's the 27th Circuit Court. Any objection, Mr. Roberts?
No objection.
All right.
And Your Honor, we're asking the court to add to the employment that my client was also employed with the 14th Circuit Court as a law clerk as well.
January 2021 to August 2021.
January 2021 to August 2021, Your Honor.
Okay. Any objection, Mr. Roberts?
It's a fairly minor point, but I think technically that was an internship. I don't know if that qualifies as employment, but I'm not. If the court wants to put that in there, that's fine.
Yeah, I thought the same thing. I mean, we don't differentiate between, I guess we can say rate of pay as an internship. I think that kind of will make sense to me. Any objection to that, Mr.?
That's appropriate, Your Honor. We will support that.
Okay. All right.
And on that same page, Judge, under colleges, advanced degrees, the second one down, West Michigan University, Cooley Law School, under level completed, it says 3 years college, 4 years college, and it should be 3 years. And the area of study should be law, not legal assistant.
Okay. Any objection, Mr. Roberts?
Objection.
All right.
And certificate, I'm sorry, you're correct. Certificate should be Juris Doctorate.
All right.
Correct.
Okay.
Okay, on the next page, page 8. And this also was not included in my original email, Judge, under mental health, where it says bipolar disorder.
Okay.
We now have the medications that's been prescribed, and I'm going to spell them for the record. The first one is Lamistol. Lamistol?
It's Lamictal, C, not S.
Okay, Lamictal.
TIL.
Okay, Lamictal. And it's spelled VISTARI. L?
L at the end.
Okay. VISTARIL. Visceral. And the treatment commenced in 2024. Okay. The third page one, the following page, under basic information, highest grade completed. It says bachelor's degree. That should be Juris Doctorate, Your Honor.
Okay. Any objection, Mr. Roberts?
No objection.
And thank you, and I have no additional corrections to make to the PSI.
All right. Any additions or corrections to the guidelines at all, Mr. Roberts?
No.
And Mr. Johnson? Any corrections or additions? Any corrections to the guidelines at all?
No, sir.
Okay. Any challenges of the guidelines, Mr. Roberts?
No, Judge.
And Mr. Johnson?
No, sir.
All right, Ms. Vander Ark, have you an opportunity to review the pre-sentence report and the attached guidelines?
Yes, sir.
Any additions or corrections that you have?
No, sir. I got all.
Okay, Mr. Roberts, I believe we have some individuals here who wish to make victim impact statements. Is that correct?
That's correct, Your Honor. The two older siblings of Timothy Ferguson, with the exclusion of Paul, would like to make a statement.
Okay, they may come forward, and whoever wishes to speak first may go ahead and they can stay there. They can come to the podium. It's completely up to them. So,
It's Millie Ferguson who's going to be first.
okay. And just for the record, I think Ms. Ferguson actually wrote a letter as well, I believe. And
I believe it's included, yes.
yeah, I have read that's attached to the PSI, but she's certainly welcome to make a statement. So. Good afternoon, ma'am. How are you?
I'm good. How are you?
Can you please state your name for the record?
Millie Joan Ferguson.
Go ahead, Ms. Ferguson.
Thank you. I'm Millie. I'm Timothy's youngest older sister. I'm 2 years older than him. One of my earliest memories I have was being taken away from my parents by CPS. My two older brothers rode in a car ahead of us, and me and Timothy rode together in the second car. And in every picture we have as a family, Timothy was always right by my side. We were the two youngest, the two smallest. We were the two that sat in the middle in the backseat car rides with the too small car. The last two to get hand-me-downs, the two that never had to worry about not getting homework help from an older sibling. He was always 2 years behind me, so every time I got to the next level in school, that's how many years I had to wait for him to follow along. When I was in 8th grade, he was in 6th, and there was a student in my science class that started talking about him, trying to start rumors. I stood up right as class was starting, as people were quieting down, and I shouted at him to never talk about my little brother. People could say whatever they wanted about me, I didn't care, but not about him. and never about him, because I was his big sister. It was my job to protect him. I like to say I don't regret things in my life, that every mistake I've made has made me who I am today, but when Timothy died, I couldn't stop regretting. I regret not hugging him more and teasing him so much instead of telling him that I loved him every once in a while. I regret not putting aside my differences with Shanda and Paul just to check in on him. I regret not dancing with him the last time I saw him at our brother's wedding. These are the things that I can't remedy now. There's no fixing what's been done. No way to redo it all over again, and that's my regret. That I couldn't protect him when he needed me most. Timothy was so smart. He could take anything apart with any tools, or none at all. He had trouble focusing, but when he did, he was just as smart as the rest of his class. He made people angry, yes, but then he would look at you with those big baby blue eyes, and you could never stay mad at him. It took me 6 months of therapy after he died to even properly feel the emotions of his death. And I'm still in therapy today. I've been trying so hard since he passed away just to try to let people know of him, let people know that he was loved, that there are people out there grieving for him. I'm here today for him because I was asked to speak for him, because I was given a victim impact statement for him instead of a witness one, because the victim of this crime can't speak for himself. I knew him his whole life. I held him the day he was born, and I continued to try to hold his hand as long as he was by my side, until he wasn't. I want the woman who killed my little brother to face the highest punishment possible. I want her detained for the rest of her life so she can't hurt anyone else. And I want the world to know that Timothy was wanted, if not by her, then by me. He was loved by me. Thank you.
Nolan Ferguson will be next, Judge.
Okay.
Yeah, please state your name for the record.
I go by Nolan. My full name is Eric Nolan Ferguson Jr.
Go ahead, Mr. Ferguson.
I am Timothy's oldest brother, and unfortunately the oldest child of Shanda Vander Ark. I live with my wife 900 miles from here, and in July of 2022, I was working 60-hour work weeks, trying to build a career when I received a phone call that I never thought I would get. My baby brother Timothy was gone. For 2 days, I reeled with no explanation until I was informed that our own mother was in jail for his murder. Somehow, making an entirely unexpected and deeply awful situation worse. I thought that things were different than when I was younger. I thought my mother had changed for the better. Not one day has been easier since then. I've had to leave my career behind. My wife has to watch helplessly as I struggle day in and day out, wondering how none of us knew what was going on, wondering if I told Tim I loved him enough times for him to remember up until the very end. I have to wake up every day and pretend that I am who I was before Timothy died. I have to pretend to be Nolan so that my friends and coworkers and family won't worry about me more than they already do. I'm surrounded by people who love me and care about me, but not a single person besides my sisters who understand how hard it is. Timothy wasn't surrounded by people who loved him when he died. And if I had known that, nothing could have stopped me from rescuing him and holding him in my arms and telling him I love him, that his big brothers got him, just like I did the day he was born. But because of Shanda Vander Ark's actions, I instead got to cradle the bag of his ashes in my arms, just like I did the day he was born. In all my life, I only knew one thing that my little brother didn't like. He hated goodbyes. If he had to say goodbye to anyone, he would cry and he would hold you and he would say, "Don't go." But now I'm the one crying, but I never got to say goodbye. I will always love Timothy like I always have, and it kills me to think about, but I know he loved even his abuser and killer up until the very end, because unlike me, that's all he was capable of, love. I, on the contrary, want to stand here and express the anger and hatred that I feel, but if I'm honest, all that's just a mask, a bandage I try to put over the hole in my heart that was reserved for Timothy, but is now just filled with pain and remorse for every hug, high five, and I loved you that I might have missed in the time that I had with my sweet baby brother. So now I turn to the justice system in hopes that in addition to serving the maximum penalty, that there will be no appeals or second chances. If I can't have my brother back, she shouldn't have her freedom back. And lastly, I want everyone to know that to those who knew him, even that wouldn't feel like justice. Because the life of one sweet little blue-eyed boy is not equivalent to that of a murderer.
Thank you, Mr. Ferguson.
That's right. Thank you, Judge. I want to preface this by saying that those of us involved in the justice system, including the defendant, know what sentence the court is going to impose here, at least for that first-degree murder charge. And it is a sentence which is as warranted in this case as ever there was a case. That life without parole is the only sentence that Ms. Vander Ark should receive. I wanted to stand here for two reasons. I wanted to stand here, up here at this podium, next to Millie and next to Nolan as they gave their statements for two reasons. One, to show that we support them, that we support whatever statement they wanted to make here today. But I also wanted to see Ms. Vander Ark. She didn't look over at her kids once. Not once during this entire process did she look over at her children. And that speaks volumes, because this case has always struck me that it's impossible as a parent, let alone as a human being, to understand the depths of the depravity that it took for us to come here today. All of the things that she did, or all of the things that she withheld, or all of the things that she directed her other son to do are so callous and so cold that they just defy explanation. And I convinced myself that the only thing that could make any sense is that on some level, she had stopped thinking of her children as human beings. And frankly, her not looking over and not even wanted to express some type of emotion or some type of remorse or some type of recognition of those two older children that she had a hand in raising and who spoke so eloquently and so beautifully and so passionately here today, just reflects what I guess we already feared and already knew about Ms. Vander Ark. By a long margin, this case has been the most difficult case that I've ever worked on as a prosecutor. There are a few people that have had any contact with this that wouldn't say the same thing. Whether it's police officers, whether it's the first responders, whether it's the paramedics or the firefighters who were on the scene, who all needed counseling to get through it. To the prosecutors that have looked at this, to the other attorneys that have looked at this, to anyone you talk to, nobody can look at this and understand any of this. And certainly nothing in Ms. Vander Ark's testimony, we know it wasn't persuasive for the jury, and nothing in her testimony can provide any real insight into what was going on here. Again, other than what I feel is the conclusion here is that her children were just not people to her, that she just stopped thinking of them as that. They were, certainly Timothy was just an obstacle to her. He was a challenge that she was going to win. She was not going to let Timothy win. And she said it over and over again in the text messages. And it's just unfathomable. Again, I know the court has no discretion to impose, and we certainly welcome and stand wholeheartedly behind the court here having to impose the life without parole sentence. But I would say this, the court does still have some work to do because it does have to impose a sentence for that first-degree child abuse case. And as the court is aware, and we've not contested the guidelines in this case, they call for a minimum sentence of between 135 and 225 months. But I submit to the court, if ever there was a case where the guidelines don't even come close to reflecting the charge, it's this case. If not this case, then I can't even fathom what case it would be. Even with the offense variable scored at nearly double what would be necessary to maximize that score, that still doesn't even scratch the surface of what this woman did. I don't know, frankly, what number to suggest to the court. For years, I practiced in front of Judge Hicks. I know that Your Honor did as well. And Judge Hicks would frequently throw out numbers when he was discussing the discretion that the court has for life offenses, to throw out just numbers that just seem ridiculous. They don't seem ridiculous in a case like this. They just don't. Because nothing, again, can touch what this case was. Nothing will bring Timothy back. We all know that. We can't escape that tragedy. That the time for that has passed. But I would ask the court to send a message here that reflects how heinous, how callous, how cold, use whatever adjective you want to describe these actions, that even for that first-degree child abuse case, that's what this sentence should reflect. And those guidelines just don't even come close. So I leave it in the court's discretion here. And again, knowing that despite what decision it makes on that charge, it has no discretion with the life without parole sentence. And the only solace I take away from this, and I hope all the relatives and all the loved ones and all the people that cared about Timothy know that the only thing we can do at this point, and the only thing this court should do at this point, is to make sure that Ms. Vander Ark never sees a day of freedom again. Thank you.
Thank you, Mr. Roberts. Mr. Johnson, any allocution on behalf of your client prior to sentencing?
Yes, Your Honor, if I may. Very few people, I think, in this courtroom have the experience of going into a jail to meet your client for the first time. I know Your Honor has. And it's a strange feeling to go in there, because usually when we go in there, Judge, we've read a police report. And in some of those cases, it describes something just horrible. It's just a terrible thing that's happened. And we go into those jail cells and we see this client, and we're looking because we're expecting to see horns in the tail and the pitchfork. That's what is being described. And we get in there and we see just a person who is now facing jeopardy due to the worst thing that she's ever done in her life. And whatever else has made this person that way is not in the guideline scores. In my client's case, Judge, as you've read the pre-sentence and the people have read it and it's been admitted, her father, her biological father, my client's biological father, died when she was 8 years old. And he also sexually and physically abused her, which means he began before she turned 8. And as the court is aware, we don't catch these guys the first time, and especially when force and violence is used, they can hide their transgressions for years. Once this man is out of her life, another man comes into her life, her stepfather, who does the same thing until she's old enough to move out of the house. The court is also aware that my client has also had the burden of mental health issues. And quite frankly, the reality is when people are conditioned to believe that that's the sort of treatment that they deserve by their father and their stepfather, and their mother's not going to protect them, they tend to seek out that sort of abuse in the spouses. So the abuse continues all through the youth of her life until she finally frees herself with this man. And what does she do when she frees herself? She puts without resources, she has no wealth, without resources, she puts herself through college. She puts herself through law school. She not just puts herself through, she's second in her class in college, and she's second in her class in law school. And she has, eight books from law school, which she's, jokingly told us twice when her stepfather had. They talked about those things. She goes on and she provides a home for her 3 children and her ailing husband while going to school full time, while being a mother full time, while working full time. She does all these things, but she makes a mistake. She makes one decision she shouldn't have made. She says yes. She has no criminal history. I couldn't find a speeding ticket. She raised dogs. She did Herculean stuff. When she got that phone call telling her that Timothy is either going to come to her or he was going to go into foster care, she says yes. Had she said no, I already have a house full of people I can't afford. We don't have the resources. Had she said no, my husband's sick. I have a 20-year-old son who's still living off us, sleep on the couch. Had she said no, Timothy would be alive today. And he would probably be in the loving care of a foster family, probably someone who could take care of kids with special needs. Had she said no, with her academic backgrounds, and quite frankly, given the fact of she has a relative in the legal profession who's highly regarded in the profession, she would now be practicing law and probably be doing very well at it, given her academic abilities. But she didn't say no. She did what moms do. She said, that's my boy, my baby. I'm taking him home and I'm bringing him into the house. She brought him in knowing that she shouldn't have him there because she doesn't have custody. She brought him in knowing that she couldn't get him into schools and get him in the because she didn't have custody. Her ex-husband was not going to assist her in that. She brought him in knowing she wasn't going to get any more financial assistance. It wasn't her intention for us to be here. It was never her intention. Something broke. If she had said no, or if we wouldn't be here, something broke. Judge, this case makes no sense to anybody. There is no gain for her from this conduct. And if the court heard the transcripts of those emails, those text messages, she and Paul are unaware of the damage. They don't see it. How could you not see it? Because something's broken. There's no specific intent here. There's no intention. Her intention was to mother her kids like she did the other two children that were in her household. That was her intention. Her intention was to provide, as she did with the other two kids. You don't see this with the other children. This is something about this boy and this woman broke. 30 years ago, we didn't know about postpartum depression. 20 years ago, we didn't know about postpartum psychosis. Someday, somebody's going to tell us what's wrong with this woman and why anyone would be capable of what she did. Someone's going to explain it. 400 years ago, we burned people like her at the stake because the bloodlust was there. And that's what made people feel better. And that was their solution to a horrible situation. Well, there is Mr. Roberts' description of this offense. Nothing's inaccurate. Nothing he said do I disagree with. But I think you have to add in the part that something's wrong here. Something's wrong here. And even if we can't put a label on it, we all know it. Timothy was her blood son. This wasn't some child. This wasn't a financial gain. This wasn't a stranger. This was her blood. She gave birth to this boy. And yet she was able to do what she did. Something's broken. The human mind just its capacities and its reasonings. I don't claim to understand, but we can look at her life before then and the circumstances, and they come together. And unfortunately, Timothy is the victim of it. That we get that. But the idea that this is premeditated or she intended, when they found the video show when she was surprised. She was surprised when he passed. Something's amiss. And I'm asking the court to respond to that reality. The easiest thing would be to exceed the guidelines. But I'm asking the court to do the hard thing, and that is to respond to reality. This is a person who, if she had said no, 10 years from now, she'd be practicing law, and people would be asking her to come and to speak at high schools to talk about how you overcome what you've overcome, the mental health issues, the abuse from man after man after man.
was a survivor and a person who pulled herself up by her own bootstraps, no resources, all on her own, all her effort. This is what she's done as well. And it's unfortunate. It's horrible for Timothy. And it's horrible for her. But at the end of the day, we're not looking at evil, we're looking at sick. And I'd ask the court to apply that standard. Thank you.
All right, thank you, Mr. Johnson. Ms. Vander Ark, do you wish to say anything prior to sentencing? Well, first and foremost, for the individuals here to speak on Timothy's behalf, I appreciate you being here. It kind of struck me throughout the trial, you know, who was here for Timothy. And at one point in time, I worried that we may not have anyone to give a victim impact statement. And that to me made me very sad, quite frankly, horrified more than anything, but quite sad. And I'm happy that two individuals took time to be here from miles across the country. And out of the horrible situation, that makes me feel a little bit better. Not much, but a little bit better. You know, Mr. Johnson makes the same argument today that he made at the trial, that this was just negligence. This was her not understanding what was going on. She was really trying to do the punishment. She was trying to be a good parent, and she just didn't realize that Timothy was in such a horrible condition. And I found myself, especially during closing argument, quite frankly, finding myself almost believing that. And afterwards, after the trial, I sat in my car after leaving that day, trying to understand, you know, why I could feel that way. And what I realized is that I wanted to feel that way because I didn't want to accept the reality of the situation here. And the reality of the situation here is that this person, Ms. Vander Ark, you intentionally engaged in these acts. This wasn't negligence. This is not understanding why, but you intentionally did this with a goal. And I think Mr. Johnson's correct. I don't believe there was an intent to kill here, because you would have lost the very thing that you wanted to torture. Without him, you have no one to torture, except maybe the younger children. So I don't believe you intended to kill him. I think you intended to continue on torturing him for as long as you possibly could. The why, I don't know. But all the information that I have in front of me, and I sat down, I really thought about this, and I looked over my notes from the trial, demonstrate that this wasn't negligence. This wasn't you not understanding what was going on. You look through, I read through every single text message of the exhibit, 2,000 plus pages, to try to understand what the heck was going through your mind. And what became entirely clear to me is that you knew exactly what you were doing. Immediately afterwards, when police arrive at the home, you immediately concoct this lie about he's been on a hunger strike. He was in the bed and I checked on him and I gave him some food and all this stuff. You got Paul involved in it. At one point in time, put baggy clothes on him. Put clothes on him to make sure, I guess, that he looks like he was actually wearing them, that he was hiding his poor condition, even though you already received text messages, weeks earlier of how bad he looked. You testified yourself how highly intelligent were. In fact, that's the only thing that you testified to that I think was actually true. You were quite proud of that, boasting how intelligent you were. And not only that, but your actions in hiding this child. you hid him from his grandparents. You made sure that your other son, G, or little man, as you call him, didn't see him. You know, those text messages talk about not wanting anyone to see him. I want to see him in that condition. You made sure that the garage was closed. When you sent him out, there was no pants on to clean out the garage. I don't want to believe it because I don't understand. I can't wrap my mind. I've been trying now for this entire case to wrap my mind around how somebody could do something so horrific, not only to another human being, but to their own child. I'm a father myself. I love my kids. I love them with unconditionally. But quite frankly, there's a mother's love that I've seen that is striking. And anybody who's a parent who's married, most mothers, and not all, but most mothers have such a strong love for their children. And to see what you did to your own child, I don't know if there's a word in the English language to describe how to describe it. I only can come up with just horrific. You intentionally and systematically tortured this child. And let's call it what it is. It's torture. You tortured this child. This wasn't punishment. This wasn't trying to curb his behavior. You tortured him. You monitored him obsessively. All the things you did. I looked through every one of the messages: bread with hot sauce, wall sits, up and down the stairs, sleep deprivation, ice baths, making him puke up food, monitoring his bathroom time, giving him 60 seconds in the bathroom if he went to urinated, or 5 minutes if he had a bowel movement. You made him sleep in the closet. You threatened us to make him sleep in the garage. You put Tabasco directly in his mouth. You made him put his hands over the head. Made him work in the garage with no pants. And you know, there's two other things that didn't come out in the trial that were in the messages. One, that there was talk of blindfolding him, depriving him of his physical sight as a punishment. And the last thing that struck me is just absolutely horrific in terms of your thinking. There was mentioning of giving him salt water as a punishment. One of the text messages talks about, hey, tell Paul or tell Tim that I'm not going to do the saltwater punishment. And your reasoning for not punishing him was that, oh my God, we can't give him salt water, that could hurt him, that could kill him. But it was because you didn't want to give him another excuse to sit down on the toilet because he'd have diarrhea. He'd have diarrhea, and so he would have an excuse to sit down for a few more minutes while he was diarrhea from salt water. That was your excuse. That was your justification, not that it would hurt him. And you did so for what? Because of some punishment. You wanted to regulate his food, even though you yourself testified that he didn't really gain a lot of weight. Toward the end of these text messages, you and Paul are talking about not wanting him to win. He's not going to win. I didn't allow pictures to be shown in open court of Timothy as he was when he died, because I didn't want people to remember him like that. Of all the things you took away from him, one thing I didn't want you to take away from him was at least some shred of dignity. And then I also thought, well, I'm a judge, I'm a human being. I don't know how to right this wrong. We try to do that. I try to do that from the bench every day. There's no way to right this wrong except impose a sentence that essentially takes away your freedom. And I thought to myself, what do I do? And I will tell you this, I'm choosing not to remember your son dead, looking like a Holocaust victim, but I'm choosing to remember like that. And you can't even look at him. That's how he was. A beautiful child with a lot of life in his eyes.
That's who your son was. And you took that from him. I'm choosing to remember him as a happy individual with life, not as an individual. And that's the picture I want people to remember of your son. You took that from him. You took it from him. For what reason, I don't know. Mr. Johnson's right. There is something broken in you. I don't know what that is, but it doesn't negate what you did here. So besides remembering him like that, I'm not going to let you hide in the darkness anymore. People know what you are now. They know what you did. You're not able to hide in the darkness anymore. Timothy won. And he won because we know what you did to him now. It's not hidden anymore. We know who you are. That's the way that I'm going to honor him. You don't win because justice, thank God, in this case prevailed. I can't even imagine if you had been able to resuscitate him. He'd be still suffering. So if there's anything I'm grateful for, would be that he finally passed away so you couldn't continue to torture him like you did. It's a sentence of the court. First, as to count 2, child abuse in the first degree. Court sentences you 50 years to 100 years in prison. Credit for 575 days. Court is exceeding guidelines in this case. The court finds that the amount of torture that I've indicated in terms of the long-term suffering that Mr. Ferguson, Timothy went through justifies on a reasonable grounds to depart from the guidelines. Used to be the standard was the guidelines. If the guidelines had taken into consideration all the elements, I don't think they would take into consideration the amount of absolute systematic, consistent torture that you engaged in here. I think that's enough reasons to justify departing from the guidelines. There's a $68 state cost, $130 crime victim rights assessment. As to count 1, felony murder. It's a sentence of the court. You serve a term within the Michigan Department of Corrections for the rest of your natural life without parole. Again, there's credit for 575 days that you've already served. There's a $68 state cost. The crime victim assessment fee has already been assessed. The court is going to assess a $450 public defender fee. Ms. Vander Ark, you have a right to file an application. You have a right to file an appeal. Request for this, if you are unable to afford an attorney, one will be appointed to a public expense. Request for assistance to the lawyer must be made within 42 days from today's date. Clerk is handing you a form that you must complete. Return to court in that 42 days. Mr. Roberts.
Judge, just briefly, I believe you did indicate you would order that $5,000 in restitution.
Oh, I did. Thank you, Mr. Roberts. The court will order $5,000 in restitution at this time to the Michigan Department of Health and Human Services with the caveat that Mr. Johnson, you can certainly, if after the documentation, you can certainly ask for a restitution hearing and to contest that amount.
Thank you, Your Honor.
Anything else for the record, Mr. Roberts?
No, thank you, Judge.
Mr. Johnson?
No, sir.
All right, we're adjourned.
Yes,
Accuse me for being overstep.
Well, that's what.
Well, I definitely love how the judge took his time, went through there, explained to her, look, I looked at all those text messages. I seen how you tortured him. And that has to hit from the bottom of somebody's heart for you to say, I'm glad that he's gone now. So now everybody can see what you have done and that you were going to do nothing but continue to torture him. Oh, man. Man, oh, man, oh, man. What a mess. So we seen her go all the way through. The only thing that I do have Timothy's sentencing up. I don't know if y'all want to hear his, but the same judge did his. I can show y'all his real quick.
All right.
Not that
Come to
long.
order. 14th Circuit Court, County of Muskegon is now in session. The Honorable Matthew R. Casel is presiding. And you may be seated.
Before the court is filed 22-3537 FC. It's people of the state of Michigan versus Paul Ferguson. Are you Paul Ferguson, sir?
Yes,
Your
sir.
dates of birth.
Yes,
Are you
sir.
Paul Ferguson?
Yes.
All right. Mr. Ferguson appears before the court with his attorney, Mr. Joshua Elton Brady. The people are represented by Mr. Matthew Roberts. Same time scheduled for a sentencing in this case. Have the people had a chance to read the pre-sentence report and the attached guidelines?
We have, Your Honor, we have no corrections to that, although I know the court is in receipt of a letter this morning, as we all are, from Paul's older brother. We have no objection to that being included in the report as well.
Is there any objection to? I did receive a letter from Nolan Ferguson, who was here and present for Shanda Vander Ark's sentencing, and I did receive that this morning and didn't have a chance to read that before I came out. Do you have a copy as well, Mr.
I have a copy, yes, Your Honor, and I have no objection to that either.
Okay. Also, the court is in receipt of two assessments, psychological assessments. One is from a Thomas D. Shazer, psychiatrist, forensic psychologist from Ann Arbor. It's 25 pages in length. That was submitted by defense counsel at the urging, I will say, of the court, asking for that. So I appreciate that, Mr. Alvin Brady. I also am in receipt of a report from a Sami Farhat, a PhD, licensed psychologist. This is a 7-page report. It's a psychological assessment as well. It was also provided by defense counsel. Court has reviewed those in anticipation of sentencing. Mr. Roberts, have you received a copy of those?
Yes, I have.
And Mr. Alvin Brady, and any objection to the court reviewing those and considering those as sentencing, Mr. Roberts? Mr. Alvin Brady?
No objection, but I would ask those be considered as non-public
Yeah,
exhibits.
the court is going to have them scanned into the court file, but they are going to be non-public. They do contain a large amount of what I would consider very personal medical information that I don't think is appropriate to be in the public domain. The court is going to reference certain conclusory conclusions from these reports, but those do not reveal specific medical information. I think it's appropriate, so the court will make these part of the record because it's going to be considered those in sentencing, but again, it's going to be non-public. So, all right. Any additions or corrections you have to the pre-sentence report, Mr. Roberts?
Beyond that addition, no, I have none.
Okay, Mr. Alvin Brady, have you an opportunity to review the pre-sentence report and the attached guidelines?
Yes, I have no additions or corrections. I would also note, as we're on the topic of letters, I submitted a letter from Stephen and Martha Vander Ark. Those are Mr. Ferguson's. I believe those would be step-grandparents, the current placement of his younger half-brother, G. They had intended to be here in support this morning, but were ill this weekend.
Okay, yeah, I have also considered that too. Did you receive a copy of that as well, Mr. Roberts? Okay, I read that too. I've gotten a large number of letters from people that I would say unrelated to this case specifically, just individuals who saw it on court TV and expressing an opinion. I am not considering those in sentencing because, one, they're not directly connected to the case. And I do appreciate the comments from individuals, but I think it's important to be limited to the record to the people who actually have something to do with this case or connected with the victim. So unless there's an objection to that, I've read them, but I'm not using it as a consideration. So any objection to that, Mr. Roberts?
Okay.
Mr. Elton Brady?
I would note, not having seen copies of those, I can't comment on the specific letter, but no issue with that. Your Honor.
Yeah, I mean, there's just random people who saw it on TV, and I just don't think it's appropriate for the court to take that into consideration for sentencing purposes. I don't think that's fair to Mr. Ferguson. So no additions or corrections, Mr. Elton Brady?
No additions or corrections.
All right, and Mr. Ferguson, have you received a copy of the pre-sentence report and the attached guidelines?
Yes, Your Honor.
Any additions or corrections you have?
No, Your Honor.
And have you had ample opportunity to discuss the contents of that report with your attorney?
Yes, Your Honor.
Mr. Roberts, do we have any victim representative who wishes to make a statement today?
We do not, Your Honor.
Okay, any comments regarding sentencing?
Yes, Your Honor, thank you. As I've said to the court before, this is, as it relates to Paul, this is one of the most difficult cases I think I've ever had to deal with, not just from the standpoint of how difficult the subject matter was here, the tragic death of Timothy and the circumstances surrounding it, but just with Paul himself, and I'm not saying anything today, but really that I have told Paul in multiple meetings that we've had in leading up to the trial and his cooperation here, that I view him as favorable in that he was willing to help us and to testify against his mother, which I'm sure was very difficult for him to do under the circumstances, but that I was also angry, just frankly angry and shocked and appalled that his treatment of Timothy, because he was, for all intents and purposes, the enforcer arm of this two-person, the two people most directly responsible for Timothy's death, that he was the one that would deal out most of the punishments that were directed by Ms. Vander Ark, and certainly she's received the appropriate sentence for her role in this as well. So I had mixed emotions about Paul, even up to and including the time that he testified in this trial, and those frankly continue. One of the things that we discussed at the time of the plea was giving Mr. Brady an opportunity to get the evaluations, which we now have, in an effort to hopefully demonstrate in some regard why Paul did these things. Was it a psychological condition? Was there some manipulation taking place? And quite frankly, I think just as my feeling is there's good and bad with Paul, I think both of these assessments reflect the same thing. What is absolutely clear from both of these assessments is that whatever upbringing Paul had from his mother and frankly from his father as well, led to him being how he is today. And that was a childhood that I think both reports indicate was marked with abuse and neglect, a very traumatic upbringing, moved around a lot. And what also rings through in these assessments is that nobody did anything to get Paul any help when it could have made a difference. So that is in some respects, that's the good part of this, because it does seem to at least explain in some regard why Paul behaved the way that he did. But there's bad in here as well. I'm sure the court will note this, but the one sentence that struck me in Dr. Shaser's report is that it says, in my opinion, Paul Ferguson was predisposed to abuse his brother independent of his mother's presence and active influence in his life. That's frankly scary. And there's other scary parts of this as well that indicate that Paul was, at least in some respect, predisposed to being essentially a bully. And that's how you could view his behavior, is that he was a bully. Now, nobody, I think, would expect any bully to take it to the extreme of actually killing a person, although certainly it does happen, but nobody would expect that was an intentional outcome that Paul sought here. And we can't lose sight of the fact that Paul didn't become this way in a vacuum, that his upbringing in some respects led to him being predisposed, as this report indicates, and I think the other report references as well, that he was predisposed already doing some of these things. Frankly, I think that Ms. Vander Ark took advantage of that and used Paul because she saw an opportunity to have Paul do the horrible things that she couldn't do herself or wouldn't do herself, but be done at her direction. And Paul was unfortunately willing to go along with those things because of everything that had happened to him, because of his traumatic upbringing and because of the conditions that he did have that led to that. So it's hard to balance these things out. But certainly we did not have this report at the time that Paul pled. And I don't know that in looking at this report, the decision that was made in this case would be any different. But certainly there are things here that would have been nice to have been able to consider, but we didn't have the benefit of that. And as I told the court, I think I told the court on several occasions in speaking to the jury, they were, in Ms. Vander Ark's case, very much impressed by, might not be the right word, but certainly factored in Paul's testimony a great deal. Believed that he was telling the truth, believed that he was honest about what his role in this and Ms. Vander Ark's role in this. So I think his testimony was instrumental in achieving the conviction that was achieved here against Ms. Vander Ark. So I certainly owe Paul that consideration. But beyond that, I certainly don't envy the position the court is in today. In balancing everything that has taken place here, the good and bad, even in this report, and the good and the bad with Paul, I will stick to the agreement that we made here. I will ask the court to sentence within the sentencing guidelines in this case. Certainly the court is obviously free to exceed the guidelines if it feels there's a basis to do so. And quite frankly, there are reasons to exceed the guidelines. In some respects, there's reasons to go below the guidelines as well. So literally, I think any number that the court chooses to pick here, I think would be the appropriate sentence, because I think it's a difficult balancing act that the court has to do here. But my commitment was and continues to be that we would ask the court to sentence within the sentencing guidelines. I would ask the court, however, to impose a maximum number here that is essentially equivalent to what Paul's life expectancy would be. And the reason for that is that if some of the bad that's indicated in these reports is actually present and Paul does not receive treatment for that, and those conditions that are noted here, most notably the potential antisocial disorder, essentially a sociopath, if those things are borne out in the prison system, that the prison system then has the opportunity to keep Paul locked up as long as possible. I hope that he can get some treatment inside there, but the bad in here has got to be addressed, and if it's not, then certainly Paul does represent a threat to the public moving forward because of his disassociation, essentially, from feeling empathy or feeling bad about the things that he had done. In the moment, it did not appear that Paul felt bad about those things. There certainly was a moment where he thought he needed to let his mother know that Timothy was very thin and that they should start feeding him, but overall, what comes through in these reports is that for the most part, those were absent, and the text messages, I think, even bear that out as well. But even after that noting of the fact that Timothy was very thin and that they needed to start feeding him, Paul was still a willing participant in the truly tragic and horrible things that happened in the last days of Timothy's life, including the prolonged ice bath that Paul watched over. So certainly that bad needs to be addressed as well. So again, I don't envy the position the court is in today. I will stick with my commitment here and ask the court to sentence within the sentencing guidelines. But quite frankly, any number that the court picks here, I think would be an appropriate sentence for Mr. Ferguson. I'm pleased that we've been able to achieve whatever justice we could for Timothy here in both of these convictions, and certainly the two people most directly responsible for what happened to Timothy are going to, in all likelihood, be incarcerated for an extended period of time, certainly in Ms. Vander Ark's case for the rest of her life, which is completely justified under these circumstances. So I would ask the court to, as it will have to do, to weigh the good and the bad here in these reports. And I trust the court's, I trust whatever decision the court makes here. All right.
Your Honor, I'd like to start by responding to a point that Mr. Robert made before I go into the multiple points I plan to address. I understand the prosecutor's characterization of Paul as being the enforcer, as being the primary one. But I believe part of that is based simply on the evidence that we have. This court's heard the text messages, extensive text messages of Ms. Vander Ark instructing Paul on what he was to do to Timothy. You've heard Paul's testimony about what he was instructed to do and what he did. The rest of the time, when she was there doing whatever she did, Paul was at work. She didn't have to send text messages to herself. Timothy's not here to talk about what happened when it was just him and his mother. So I disagree with that characterization. I believe, based on what we do know of Ms. Vander Ark, that there was far, far more that went on. There was far, far more that she did that there simply is no evidence of, no one to speak of, because the only person alive who knows what she did is her. Beyond that, reading the pre-sentence report in this case, I can't argue with the reasonableness of the recommendations in the pre-sentence report. I also really can't add anything about the offense, about the details of what happened to Timothy. You presided over the same trial that I watched. I know in motions, other paperwork submitted to the court, you're aware of far, far more than what came out publicly, what was submitted to the jury. But I'd ask the court to consider, I think there's 5 fronts on which Paul should be evaluated very differently than where his mother is. And the first is just capacity to understand. We heard Ms. Vander Ark's attorney argue they didn't know what they were doing. They didn't realize that it could kill him or cause that level of injury. And I don't have to come to a conclusion. I don't have to say I think that's right or that's wrong to understand that a 41-year-old law school graduate who was, by her own boasting, at the top of her class, who passed the bar with flying colors, who would have been an attorney, well, academically was qualified to be an attorney. We never got an answer of why she wasn't. And who worked for the court, both from a legal front, from a moral front, from an intellectual front, had far, far more capacity to understand what she was doing and the potential consequences of what she was doing than her son, who was a 20-year-old high school graduate who worked as a dishwasher. There's simply no comparison in capacity, in life experience, in an ability to understand and recognize what was happening. Second, well, we recognize, for purposes of the child abuse statute, for purposes of Paul's plea, the law may not distinguish between a parent and another person over the age of 18 who's placed in charge of a child. We all know a mother has a very different role than a sibling. We all know that there's a certain level of rivalry, a certain level of competition that we expect between siblings, which is very different than the care that we expect from parents. Third, and I'll come back to the text messages, it was very clear Paul was the follower and his mother was the leader in this case. Listening to over an hour of text messages read during her trial, there's pieces missing. We don't get the whole story because she talked to him on camera, or she talked to him on the phone, she talked to him in person. But what is very clear from those text messages is there is not a single time that Paul gives an instruction. Every single time an instruction is given, you need to do this, it is given by her. Fourth, and Mr. Roberts has addressed this regarding Paul's cooperation. Once the gravity of what happened sank in. I believe from the reports that was a day or so after. Paul has shown remorse. He's shown confusion over how he could have done this and recognition that it was wrong. He's testified honestly. He's fully cooperated in many areas in ways that were not of clear benefit to him. His mother did none of these things. She took the stand and lied, redirected. It's not my fault. I didn't do anything wrong. And fifth, and I think very important in looking at the evaluation of Mr. Ferguson, it's very clear that he and his other siblings were also victims of their mother. CPS involvement going back to when they were in elementary school, back when Timothy was 18 months old. A third grade teacher who said Paul and Nolan are secretive about what happens at home. They're not supposed to talk about it. So when Mr. Johnson argued in cross-examination to Paul, why didn't you report it to somebody? A lifetime of being told you're not supposed to talk about what goes on at home. A lifetime of being isolated, separated from peers, having no meaningful social contacts outside his household. That all started with her. A record that when Timothy was 18 months old, when Paul was 7, that Timothy was underfed, failure to thrive. Paul didn't have anything to do with that. He was 7. But that was the pattern. That was his entire life. That was his entire framework. That was what she taught him from the beginning, or at times failed to teach him through neglect. Mr. Roberts referenced, and I don't remember if it was in sentencing or in his closing argument, that the difference between Timothy and Paul was that Paul was useful. Timothy wasn't, at least not to their mother. And I wouldn't disagree with that characterization, but I think that's important for the court to consider. Timothy was treated the way he was because he wasn't useful. That's how children in their mother's household were treated if they weren't useful. And I believe at some level, some part of Paul understood that. He understood that we do these things to Timothy because he misbehaves, because he doesn't follow instruction, and because he's not useful. And part of understanding that is also understanding that if he didn't follow instructions, if he misbehaved, if he got on her bad side, that he could once again be subject to some of the same mistreatment. On the neglect front, I don't think any of them ever ceased to be subject to that mistreatment. And I'll end with his mother's own words from the text messages written for to Paul. Quote, "If he falls asleep for you, from you, not watching, that is not going to end well for either of you." Thank you.
Your Honor, if I can just make one more brief point, and it's not in response to anything Mr. Eldenberg has said, but the court referenced that it's had a lot of outside people contacting the court. I certainly have had that as well. And one of the consistent themes there is people believing that Paul suffers, or not suffers, it's not a suffering. The Paul is on the autism spectrum. I think it's important to note that in both of these evaluations, that's not borne out. Certainly people may have that belief and think that should be a factor here, but there's nothing in either one of these reports that supports that conclusion. So I just want to note that. That is certainly something that I think the court could have considered, but there's nothing in the report that would support that. And I don't think Mr. Ellenbrady would disagree with that point.
Yeah.
So,
I was going to reference that in my comments as well. So,
Your Honor, I think the reports do bear out that some of the characteristics that those individuals are observing and coming to that conclusion are connected to that neglect and abuse. And I believe it was Dr. Farrak characterized as normalization of abnormal behavior. So while I agree that both analysis seem to have come to the conclusion that diagnosis is inappropriate, I don't believe that those observations by the individuals mentioning that are ungrounded. It's simply that those behavioral characteristics come from a different source and therefore do not lead to the ability to officially diagnose with that condition. That does not change the fact that those characteristics are there, that those characteristics are relevant to Paul's interactions with his mother, or that those characteristics are relevant to ongoing treatment services that Paul will need moving forward.
Okay. Mr. Ferguson, anything you wish to say prior to sentencing?
Yes, Your Honor. What reasons could justify my actions? I could make up 1,000 and never believe one. What words could voice my regrets? I can think of millions, yet never feel it's enough. If I could do it all again and do it right, I would. I feel I will pay for my choices and yet never feel better because he's still gone. I have had time to think during my time in Muskegon County Jail, and I've realized many things about myself that I might never have considered otherwise. My problems and flaws, to put it simply, are the place to begin correction of self. I ask the judge for nothing more than mercy and fairness, to offer me compassion so I might learn from him. I only hope to better myself in the coming days and serve my time with what little honor I have left, and to make right my faults in search of a better tomorrow.
First and foremost, Mr. Roberts referenced the court is in a difficult position. This particular case, I think a lot of individuals saw Mr. Ferguson testify, and I think there was concerns about intellectual potential disabilities, and the court was concerned with that as well. There was also a concern whether Mr. Ferguson was the target of manipulation on behalf of his mother, and the reports that were submitted to the court really did help me a lot in trying to parse those issues out. The report specifically by Dr. Shazer is very in-depth and very well done. And I thank him for doing such a detailed analysis. So the first concern of the court was whether or not Mr. Ferguson was suffering from some sort of intellectual disability, whether it be autism or something else. And there's a couple references to that throughout his Dr. Shazer's report. And specifically, the first reference that the report had highlighted was on page 2 of the report, first full paragraph, and it says, in my opinion, he, referring to Mr. Ferguson, was clearly either psychotic or suffering from symptoms of a mood disorder at the time of the court interview. And he was apparently functioning within at least the normal range of intellectual ability at this time. Thus, in my opinion, he does not suffer from a chronic psychotic disorder, a chronic mood disorder, or an intellectual disability. There's another reference more to the end of the report where he indicates, thus, his referring to Mr. Ferguson, his educational history is inconsistent with him suffering from intellectual deficits, and as noted above, he was apparently functioning within at least the normal range of intellectual ability at the time of the court interview. In my opinion, the defendant clearly does not suffer from an intellectual disability. So the court, that was helpful in the court because as in some of the letters I received as well, Mr. Roberts indicated that there was concern that Mr. Ferguson was autistic. And I think probably more toward that was easier to maybe manipulate him and that kind of thing. And certainly the court does take someone's intellectual capacity into consideration. I think it's important to understand the full situation. So the court, and although those are two small portions of the opinion that the court referenced, they're borne out by much more in detail history in Dr. Shazer's report. Specifically, Dr. Shazer analyzed every statement that the defendant gave the police. He also watched the testimony of Mr. Ferguson, interviewed him himself. He also looked through his history from the Oklahoma Department of Health and Human Services. He looked through his history from school records, from various psychological assessments that were conducted throughout his life based on the report. So I think that opinion is well grounded in not only his interview, his review of educational records, his review of mental health records, and everything else, Health West records currently from when he was assessed when he became the Muskegon County Jail. So the court finds that to be quite persuasive in terms of whether or not Mr. Ferguson is suffering from any intellectual disability. The court concludes based on this report, well-written report, well-grounded in fact and history of the defendant, that he was not suffering from an intellectual disability currently or at the time of this offense. The second thing is whether or not Mr. Ferguson was somehow manipulated or coerced by his mother. I think all of us
would like to believe that this is a product of manipulation, that this is simply somebody doing something that they were told to do, that they were afraid. Mr. Alvin Brady mentioned that in his elocution regarding the specific text messages. Well, those specific text messages I heard as well at the trial. Shortly after the trial concluded, I asked the prosecutor's office for a complete copy of every single text messages that would occur between Ms. Vander Ark and Mr. Ferguson, because I didn't want just the snippets, the kind of highlights, or the real juicy stuff, for lack of a better term. I wanted to understand completely what the conversation was between these individuals. I read every single text message, every one of them. I think there's thousands in there, and I read it 3 times now. 3 times in total. I read it 2 months ago, I read it a month ago, and I read it last week Friday. The entire afternoon was spent reading through these things, and I think it's clear to me that Mr. Ferguson, although he says that he was scared of his mother, or there's an allegation from that standpoint, I find that just the opposite to be true based on those text messages. There is some mention about punishment, but I think Mr. Ferguson, in my opinion, being submissive, for lack of a better term, to his mother was a result that he really had nowhere else to go. He had been kicked out from his father's house for failing to obey his father's rules and for other things. And he went to his mother's house. And I don't think Mr. Ferguson really had anywhere else to go. I think he was sort of beholden to his mother in terms of, well, there's going to be consequences. Although there are some text messages, 1 or 2 of those, that bear that out, this strikes me in the text messages as more of a collaborative effort. In fact, there's some text messages where Ms. Vander Ark actually tells Mr. Ferguson that if Ms. Timothy does not behave, essentially, I'm going to leave him to you, as in that he's going to let the dog out and just log off the chain. And Mr. Ferguson also several times essentially tells his mother things that are going on that are bad. And I think it's because he wants his mother to give him the permission to go ahead and engage in punishment. So in terms of whether or not his mother, he was somehow afraid of his mother, I don't think that to be the case. Now, that was my initial feeling about it, what I took it as, and that's why I wanted the assessment regarding whether or not he was being manipulated. And luckily, we did get one from the second one I referenced, which was from Dr. Farhat, which is specific. I think he was asked to assess this particular question. And in the beginning of his assessment, he says that specifically, I was asked to assess whether Mr. Ferguson possessed a psychological disorder of traits that would render him significantly susceptible to manipulation, coercion, or suggestibility. After conducting the evaluation, I could not substantiate these traits as they pertain to the commission of the offense. As such, this report will instead explain the nature of the evaluation and my overall opinion regarding Mr. Ferguson's psychological functioning. He also opined regarding his intellectual abilities. He says, from a diagnostic standpoint, I did not find sufficient evidence to support Mr. Ferguson meeting criteria for any specific mental disorder. While one may consider whether his presentation suggested a neurodevelopmental condition, for example, e.g. autism spectrum disorder, I did not find this to be an appropriate label. Instead, I attributed his overall demeanor and presentation to factors such as a lack of socialization, normalization of abnormal dynamics and experiences, poor interpersonal skills, and emotional dysregulation. He also indicated later on that page that I was initially asked to evaluate whether Mr. Ferguson had a mental condition with traits that would have rendered him susceptible to coercion, manipulation, or suggestibility at the time of the offense. Ultimately, I could not arrive at this conclusion based on the totality of available information. Available evidence noted that he was capable of appreciating the abuse towards his brother, that he was capable of recognizing the detrimental impact it had, and that he at times disobeyed Ms. Vander Ark and tried to provide his brother with aid and support. Furthermore, despite reporting that he was under Ms. Vander Ark's, quote, psychological hold, he adamantly denied that he was coerced or manipulated into enforcing the abuse. Additionally, he recognized to some degree pleasure in having power and control over his younger brother. In this sense, while I acknowledge that he reported experiencing fear and concerns of disobeying Ms. Vander Ark, I could not reliably substantiate his involvement as being a byproduct of suggestibility or coercion. So what this court is left to conclude is that Mr. Ferguson, the way I look at this is that Mr. Ferguson in these reports, and a lot of these, throughout the report, there's talk about how Mr. Ferguson bullied his brother when he was younger. There's a mention, his stepsister, who I think was allocated on behalf of his mother, or on behalf of Timothy at Ms. Vander Ark's sentencing. It says the stepsister, and this is before the police even really told her about exactly what had happened here. Says the stepsister reportedly told the police that, quote, she doesn't know how involved Paul was in the situation, but he is the biggest bully she has ever met in her life, and he found genuine joy in tormenting Timothy whenever possible.
Just for clarification, I don't think that was Millie, that the
Okay,
stepsister.
so maybe
was
I'm
not
wrong.
Millie.
Okay, so perhaps I'm wrong about that. But this was someone who, without even knowing the full details, reported that. In one of the interviews, Mr. Ferguson indicated that he liked getting praised by Shanda and admitted he liked having control over Timothy. He reportedly admitted having power over somebody feels good. Later in the interview, I asked him whether he had felt ashamed at the time when he was abusing his brother, and he said, quote, no, he had not. I asked whether he had recognized his actions as morally wrong at the time, and he again said, quote, no, he had not. He then volunteered that on one occasion, quote, I sent her a photo of how thin he was, and when I asked why he did this, he explained that I was worried. When asked when he was worried about Mr. Ferguson, Ferguson replied that he had been concerned for his house, and that he was nothing but bones. I asked him whether he had, at the moment, thought that this abusive behavior was wrong, and he replied that, quote, that thought never even crossed my mind. A treatment plan act from July 22nd of 2012 indicates that, quote, client, meaning Mr. Ferguson, sometimes bullies his younger brother, the decedent, Timothy. The report also mentions cruelty to animals, stealing, abuse. His mother at the time, back in 2018, told staff at the clinic he's become bossy, telling his siblings what to do. For Mr. Ferguson's part, reportedly, when commenting about his being irritable, he admits that this is due to his younger siblings not listening. He gets physically aggressive towards his younger siblings. He also tried to lock his younger brother, i.e. apparently a reference to the decedent, in the closet because his brother wouldn't listen to him. So the court read this and certainly looks at this as someone who is predisposed, I think was the ultimate conclusion, predisposed to abuse his brother, specifically the victim in this case, in a history of doing that. Now, I have no doubt in my mind that Mr. Ferguson is a result of years and years and years of physical neglect and abuse on behalf of his mother. No doubt in my mind that's borne out in this report. But the court is asked to essentially ignore the decisions or his behavior because of that, and to somehow say that we're going to minimize the damage and what he did in this case because of that. If the court started imposing that standard, I think we'll be in real trouble, because every defendant that comes before this court has a horrible history, I would say. That's the reason they're here. People that have supportive parents and things go good for them typically don't come here. Now, that's not always the case. Believe me, there's a lot of interventions, but everybody has a history. And what I was looking at is whether or not this is a product of his mother or his situation. And what I can conclude is that this is not. Mr. Ferguson is trying to shift blame from his mother, from him to his mother, to say that somehow, well, if it wasn't for her, I wouldn't have done this, or she's the one that did this. At the trial, well, at her order, at her order, at her order, at her order. He kept saying it over and over and over again. So just keep underscoring the point. And if that had been an isolated incident, if that had been one or two of these things, if that had been a punishment that he administered, maybe the court could accept that. But we have an individual who was in a household for 6 months, intentionally himself engaging in torture of another person. And he doesn't, he said, well, I'm worried about my mom's going to say. Clearly, it's not borne out in these reports. He had the ability to disobey his mom. In fact, he was on the stand and almost boasted that, well, I gave him extra food. Well, weren't you worried about how your mom was going to be upset? I still gave him extra food. So what that tells me is that this has been a careful, manipulated story by Mr. Ferguson from the very beginning of this thing, that he's going to put the blame on his mom. I'm going to be manipulated. I have Asperger's. I have autism. I have Stockholm syndrome. It was mentioned him saying, well, maybe I have Stockholm syndrome. No, this is an individual. The truth of this is that we have two individuals that lack empathy, who lack emotion. And both of them, the triggering factor in this report, the triggering factor that caused
this abuse was the removal of the husband, of stepdad. Once he was gone, these two individuals were free to torture somebody, and they did it. That's what they did. And I think Ms. Vander Ark did use Mr. Ferguson. I think that she knew from his history that he was predisposed to torment Timothy. I think that she knew that he would have no problem doing that. And Mr. Ferguson walked through that door and was happy to be the enforcer, was happy to do it, and continued to torture his brother over and over and over and over until he was a shell of a person, until he was dead, died from starvation, died from hypothermia. He had no fat on him, barely any muscle on him. And the whole time, just let it happen. Let it happen. The report says it appears that the stepfather's presence in the home had prevented Paul and his mother from abusing the victim. Again, it wasn't anything to do. They were just holding him back, essentially. The overall opinion, which I think is important, is, in my opinion, although the defendant's participation in the abuse was in a part a function of his social milieu and living situation, these contextual factors were not a necessary condition for his participation. As previously noted, mental health records contain information to the effect that while they were still living with their father and stepmother, and reportedly had no contact with their mother, Mr. Ferguson's stepmother told the psychiatrist that he had become bossy, telling his siblings what to do, and the defendant himself that he would become irritable due to his younger siblings not listening. He gets physically aggressive, told his younger siblings. He also reports that he's gotten irritated with his siblings and has pushed them in retaliation. He's also tried to lock his younger brother, that is seated in the closet because his brothers wouldn't listen to him. Consistent with this, Norton Shores Police Department documents indicate that his Ferguson's stepsister told police, quote, he is the biggest bully she's ever met in her life, and he found genuine joy in tormenting Timothy if possible while they were living in the biological father's home. Notably, the defendant allegedly engaged in this abusive behavior despite there being any safety rules in place, despite his father and stepmother disapproving of this behavior to such an extent that they removed him from their home once he turned 18 because of it. In my opinion, Paul Ferguson was predisposed to abuse his brother independent of his mother's present and active influence in his life. Nonetheless, in my opinion, Mr. Ferguson's involvement in repeated acts of abuse that amounted to physical and psychological torture over a period of months reflects a general lack of empathy for his brother and a lack of remorse for his actions. Concludes that, in my opinion, there is no reason to believe that Mr. Ferguson's conduct disorder has remitted or that his participation in the abuse of his brother was not an expression of a persistent pattern of antisocial conduct. The court is concerned that Mr. Ferguson will not get the help he needs in prison. I think he's one step away from becoming a psychopath like his mother. And the court is concerned that he represents a danger to the public. That if released, he would represent a significant danger to the public. The charge here is child abuse. And I don't think this charge or the sentencing guidelines take into adequate consideration of the long sustained torture in this case. As I indicated in Ms. Vander Ark's testimony, there was a long period of months of various punishments, including bread with hot sauce. There's hot sauce that apparently contains two of the hottest peppers that we have in the world. Wall sits for an individual who practically had no muscle left. Running up and down stairs, cleaning out a garage with no pants on, sleep deprivation in itself. Putting alarms on him so he couldn't move or sleep. Making him puke up food. There's bathroom timers. Sleeping in the closet with a tarp down, which quite frankly might be considered animal abuse. But we have a human being here, making his hands over his head. And then at the end of his life, an 8-hour practically ice bath that killed him. So no, I don't think any of those things are adequately taken into consideration by the guidelines. And I don't think the guidelines, quite frankly, these guidelines don't justify Mr. Ferguson's actions. Mr. Ferguson, I think you are a product of your environment, but I don't believe you that you're sorry. I don't think you have empathy. I don't think you have any emotion whatsoever. And that's what scares the court. It really scares me. I think you're sorry that you're here. I think you're sorry you got caught. I don't think you wanted Tim to die either, like your mother, because you would get caught and you wouldn't torture him anymore. And believe me, I tried to sit here and try to think, well, maybe Mr. Ferguson's not as bad as Mom. I think you're just as bad. if not worse. If not worse. Because you had a job. You could have, Mr. Johnson actually asked you, couldn't you have brought home a thing of food for him? You could have gone to a neighbor and said, hey, my mom's abusing them. You could have grabbed him and got him out of there. You could have done any number of things to stop this. And you chose not to. Your own brother. And this is where we're at. So, based on all that, the sentence of the court, you serve 30 years to 100 years, Michigan Department of Corrections. Credit for 592 days you've already served. Court's going to assess a $68 state cost, $130 crime rate assessment, no additional costs. Mr. Ferguson, you have a right to file an appeal in this case. If it's retaining an attorney who will be appointed to a public expense, plus the assistance of a lawyer must be made 42 days from today's date. Clerk, send you a form that you must complete, return to the court in that 42 days if you wish to request the appointment of an attorney, appeal, or adjourn.
My guy can't breathe no more. He can't breathe. He is out of breath. Oh my God. Y'all see his head pop up like a jack in the box? Wait a minute. His head was down until he heard this.
Mr. Ferguson, you have a right to file an appeal in this case. If it's retaining an attorney.
Oh gosh. That is hilarious.
Michigan Department of Corrections. You could have done any number of things to stop this, and you chose not to. Your own brother. And this is where we're at. So, based on all that, the sentence of the court, you serve 30 years to 100 years, Michigan Department of Corrections. Credit for 592 days you've already served. Court's going to assess a
Oh gosh, yo, no. Let's see. He got the shock of his life.
Mr. Ferguson, you have a right to file an appeal in this case.
Oh goodness, his head popped up like a jack in the box.
Must be made 42 days from today's date.
Oh,
form that you must complete, return to the court in that 42 days.
He is out of breath, y'all. He about to hyperventilate for real. Oh, yes, he about to hyperventilate. He like, I did all of this for this. Holy. Wow, wow, wow. So we have seen them both get sentenced. I wanted to show y'all this. This is like a 2-minute video, just real quick. I want to show y'all this because this is like the opposite of what we watching now. But I wanted to show y'all this as like maybe one of a maybe like a retrial or something that a rewatch, because I've seen it, so I know what it's like, and it was good. I was kind of conflicted. It's one of these ones where you thought Paul was not guilty going in, and things kind of like change your mind. Because I don't want to keep y'all here too much longer, but let's see here.
2019, paramedics arrive at the home of 68-year-old Sheila Murray and find a horrific scene.
I saw an elderly black female laying in a bed. She was laying on her back. The bed had urine in it, and it had been there long enough that it had turned colors. It was brown.
Murray's ankle had a compound fracture, and the bone was sticking out of the skin.
The bone was dark. There was no active bleeding. There was feces around her foot and the wound. Mold had began to form on some of that feces.
Prosecutors say Sheila Murray died after she was admitted to the hospital, prompting the Tennessee Bureau of Investigation to look into her death.
I've seen cases of neglect and abuse in both children and adults. And there are patients that stand out in your memory. And Mrs. Murray will always be in my memory.
Her children, Karen and Michael Murray, are both charged with the murder and neglect of their mother.
You will hear that on August the 10th of
Now, when I was watching this trial, when I was looking at them, and I don't know if y'all got the same sentiment that I got, she do not look like she 49 years old and he 43. They in their 40s, y'all. I'm like, what? So I'm like, they gotta have some stuff going on with them. Right?
2019. Sheila Murray laid in her bed till around 5:30 or 6 o'clock, never being changed, not once.
They pleaded not guilty, and their attorneys say they were doing the best they could to care for their mother.
The family was in a trap that they didn't even realize they were in. They thought, we can take care of mom at home. But what they didn't realize was the slow progression of time, that decline that Sheila Murray suffered from.
The family was doing the best that they could do with what they had. They didn't even know what they didn't know.
If Karen and Michael Murray are convicted, they could be sentenced to up to life in prison. They would not be eligible for parole until after 51 years.
Yes, I was thinking that may be a good trial for us to rewatch, just looking on the other end of a spectrum. And the dad, I think he had something to do with it too, but dad passed away before court and charges were brought. So they got another sister. It's another sibling too, but she like is married, you know, got her family and stuff. But in some ways, because you know, they trying to say they was doing the best they could with what they knew how to do. And it's some different little twists and turns in there where, you know, I don't know, they are appealing their decision. So if those that don't know, but they are appealing it, and I don't know about that one. I don't know. So y'all know we're gonna be back in Hawaii tomorrow at 12 o'clock. It's gonna be Mountain Standard Time. I'll get the alert out there. I want to say shout out to all the new members, all the new subs, all the new chatters that we have here. We appreciate you and glad that everybody was able to hang. You know, it's nothing without the chat. So I truly appreciate you guys being here and helping. You know, you could have been anywhere else, but you decided to hang out over here and take it to trial, and we truly appreciate it. I am going to put our outro song on, guys, and just make sure that you have your alert and everything going so you can get your notification. I'll also put the Discord in there for the after party, because that's typically where they do their after party all night long. So if you want to hop onto the Discord, it's free. I will put it in the link in the chat if you want to join. That's where the after party goes down at all types of times and hours, because everybody is on different time zones, and it's a good place for you to put things and post and kind of do your 1-2 where everybody can communicate without us doing a live stream, kind of, sort of. Yeah, and other than that, I think that we are good here until tomorrow. I'll go ahead and put our outro song on. And once again, replay team, I look at the notes. I appreciate it. Thank you for all the that really helps us get out there. So I appreciate it, guys. When you go look at the videos after we post them, after they post it. All right, I will see you guys tomorrow. Have a wonderful evening, morning, afternoon, depending on where you at. And we'll be back in touch tomorrow. All right. What is that?
When Sweet Pea taps in, you know the courtroom lights go bright. Trials running long, but the family's here every night. Mars on patrol, chatter showing out. This little YouTube corner's what community's about. Therapists you know, steady holding down the floor. Behind the scenes magician, keeping peace like never before. A banner king, a rule keeper too. Every channel dreams of a mind like you. Jason walks in and the ladies lose control. Down to earth king with the warmest soul. Film freaks, kindness, man, it's always on display. Fair and sweet and cheering folks along the way. And Marilia from SA keeps the laughter rolling free. Joking, shining, keeping spirits where they need to be. We're back. charismatic, handsome, quick with a line. A comedy sniper with the perfect timing. And Lynn with the updates, always loyal, always tuned. If true crime news drops, he brings it to the room. We're a family in the chat, side by side through every trial. Sweet pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This courtroom crew is everything we admire. Yeah, no matter what the case or file, we're forever taken to trial. Take it to trial. Shamrock keeps us trending, replay queen, holding down the algorithm like a machine. Estes razor sharp, loyal through and through. And yeah, she adores chasing nothing new. Drunky the bear with the white cloth way, managing volunteers like she runs the whole land. Cynthia brings inside with take sharp and steady. Donna keeps it real, 911 and always ready. Tilly Bird's the fat queen, receipts on tap. Easy's new, but she blends right into the pack. Tennessee, hard live, try support her with pride. Melly shows up for family for cooking for his dog. A steady carrying presence through the courtroom fog. In Brooklyn in the house, always bringing that spark. Lighting up the chat like a shout in the dark. Baca loves her grand, speaks truth when it's time. Micrograms with metaphors straight up sublime. Barbara biggest supporter, heart kind and vast. Looking for missing kids, hope to truly last. Only fan from Singapore, flag name but sweet. Still shows up with love every time he takes a seat. And even the part-timers keep this place alive. Curvier, Irish Amy, Capri Law, Hellcat, our tribe. Hearts wide open, stories shared, holding space because we care. From every corner of the world we climb to spend these nights together, one trial at a time. We're a family in the chat, side by side through every trial. Sweet pea leads the way with that fire and that smile. Mods and shadows, yeah, this love is something rare. A courtroom crew with hearts beyond compare. No matter what the case or file, we're forever taken to trial. Just sweet pea in the mods and the chat we adore. This isn't just a channel, it's a family. And we couldn't ask for more.
All right, y'all. Y'all be safe. I'll see you tomorrow. Peace.